Hello, hello, check. Hello, hello, check. Hello, check. Hello, check.
Hello, everyone. Hello, everyone. We request you to remain seated as we are about to start the session. We also request everyone in the audience to keep their mobile phones in the silent mode. A very good morning to one and all present here. I, Tanaya Shah, with my colleague Harsh Parekh, take this opportunity to welcome you all to a 2-day conference organized by the Arbitration Center, Domestic and International of the Gujarat High Court in collaboration with the Gujarat State Legal Services Authority under the aegis of the High Court of Gujarat. Over the span of the next 2 days, we will have the privilege to hear distinguished speakers on the subject of institutional arbitration, its challenges, and way forward. The topic is both contemporary and ever evolving. It gives us immense pleasure in welcoming our esteemed speakers as well as all of you in the audience for the conference. We are awaiting the arrival of dignitaries and request you all to please remain seated. Please join us in welcoming the dignitaries on dais who otherwise need no introduction. It is our absolute privilege and honor to welcome Honorable Mr. Justice Surya, the Chief Justice of India, Honorable Shri Bhupendrabhai Patel, the Chief Minister of Gujarat, Honorable Mr. Aravind Kumar, Judge, Supreme Court of India, Honorable Mr. Justice N.V. Anjaria, Judge, Supreme Court of India, Honorable Mr. Justice V.M. Pancholi, Judge, Supreme Court of India, Honorable Deputy Chief Minister of Gujarat, Honorable Shri Harshbhai Sanghavi, the Chief Minister of High Court of Gujarat, Honorable Mrs. Justice Sunita Agarwal, the two senior judges of our High Court, Honorable Mr. Justice A.Y. Kokje and Honorable Mr. Justice A.S. Supaya, Shri Kamal Trivedi, Honorable Advocate General of the State of Gujarat.
honorable dignitaries on the dais, and our esteemed guests of the dais, honorable judges of the High Court of Gujarat, former judges of the High Court of Gujarat, learned Additional Advocate General, learned government pleader, learned public prosecutor, fellow advocates, mediators and arbitrators, and all stakeholders of the industry, once again, a very warm welcome to all of you. Throughout this conference, we are honored to host eminent members of the judiciary and the legal fraternity who have closely engaged with the development of law and have significantly contributed to its present framework. Their experiences and perspectives promise to enrich our understanding of the field. The upcoming sessions are designed to encourage thoughtful dialogue and deeper reflection amongst all participants while offering a clear and nuanced exploration of arbitration, an area that is both foundational and complex. We convey a heartfelt appreciation to the honorable dignitaries and respected speakers for graciously dedicating their valuable time to share with us their wisdom and expertise.
The symbolic act of lighting of lamp is keeping with our rich cultural heritage and signifies the removal of darkness and ushering in of knowledge, wisdom, and prosperity. As a part of the inauguration ceremony, may we now request the dignitaries on the dais to come forward for lighting of the lamp. May we now request the Chief Justice of High Court of Gujarat and Patron-in-Chief, Gujarat High Court Arbitration Center, and Gujarat State Legal Services Authority and Gujarat State Judicial Academy to felicitate the Chief Justice of India, Honorable Mr. Justice Surya Kant. Thank you, Your Ladyship. May we now request Honorable Mr. Justice A.Y. Kokje, Judge, Gujarat High Court and President of the Gujarat High Court Arbitration Center and Executive Chairman of the Gujarat State Legal Services Authority to felicitate the Chief Minister of Gujarat, Honorable Shri Bhupendrabhai Patel. May we now request Honorable Mr. Justice A.S. Supaiya, Judge, High Court of Gujarat and Chairman of the Building Committee to felicitate Honorable Mr. Justice Aravind Kumar, Judge, Supreme Court of India.
May we now request Honorable Mr. Justice Bhargav D. Karya, Judge, High Court of Gujarat and member, Gujarat High Court Arbitration Center and President of Gujarat State Judicial Academy to felicitate Honorable Mr. Justice N.V. Anjaria, Judge, Supreme Court of India. May we now request Honorable Ms. Justice Sangeeta K. Vishen, Judge, High Court of Gujarat and member, Gujarat High Court Arbitration Center to felicitate Honorable Mr. Justice Vipul M. Pancholi, Judge, Supreme Court of India. May we now request Honorable Mr. Justice Nikhil S. Karyal, Judge, High Court of Gujarat and member of the Building Committee to felicitate the Deputy Chief Minister of Gujarat, Honorable Shri Bhai Sanghavi. Now, may we request the Honorable the Chief Justice of our High Court, Honorable Mrs. Justice Sunita Agarwal, to give a welcome address.
A very good morning to all. Honorable Mr. Justice Surya Kant, Honorable the Chief Justice of India, Honorable Shri Bhupendrabhai Patel, the Chief Minister of the State of Gujarat, Honorable Mr. Justice Aravind Kumar, Judge Supreme Court of India, Honorable Mr. Justice Nilay B. Anjaria, Judge Supreme Court of India. Honorable Mr. Justice Vipul M. Pancholi, Judge Supreme Court of India. Honorable Shri Sanghavi, Deputy Chief Minister and Cabinet Minister of the Law and Justice, State of Gujarat. Honorable Mr. Justice A. Y. Kodje, Senior Judge, High Court of Gujarat. Honorable Mr. Justice A. S. Supaiya, Judge, High Court of Gujarat. My esteemed brother and sister judges of the High Court of Gujarat, former judges of the Supreme Court of India, Honorable Mr. Justice A. K. Sikri, Honorable Mr. Justice M. R. Shah, former judges of the High Court, Mr. Kamal Trivedi, Learned Advocate General of the State of Gujarat, Mr. Gursharan Singh Virk, Learned Government Pleader, Mr. Hardik Dave, Learned Public Prosecutor, Mr. Yatin Oza, President Gujarat High Court Advocates Association, Mr. Prithvi Singh Jadeja, Vice President Gujarat High Court Advocates Association, officers of the Advocates Association, learned arbitrators on the panel of the Gujarat High Court Arbitration Center, Mr. Janak Dwarka Das, learned senior advocate, Mr. Shyam Diwan, learned senior advocate, learned senior advocates and learned members of the Bar High Court of Gujarat, learned members of the District Bar Associations, office bearers of Gujarat Chamber of Commerce and Industry and Southern Chamber of Commerce and Industry, office bearers of Ahmedabad Management Association, office bearers of the Chartered Accountant Association, Ahmedabad, office bearers of the Gujarat Institute of Civil Engineers and Architects, members of NCLT and DRT, officers of the Legal Department of the State, Registry of the High Court, Gujarat State Legal Services Authority, and Gujarat High Court Arbitration Center, legal assistants, district, distinguished guests, ladies and gentlemen, Namaskar. It is my proud privilege to welcome you all on this momentous occasion as we have gathered today to witness the foundation stone laying ceremony of the new state-of-the-art building of the Gujarat High Court Arbitration Center and the inauguration of the two-day conference on institutional arbitration at a crossroads, challenges, and the way forward. We are deeply privileged to have these projects inaugurated by the esteemed hands of Honorable Mr. Justice Surya Kant, the Chief Justice of India. Your Lordship's presence lends immense value to our initiatives that mark a significant step in the continued growth of institutional arbitration in the state of Gujarat. His Lordship has consistently underscored the importance of strengthening institutional arbitration in India while speaking at an international arbitration forum, positioning India as a reliable hub for arbitration. His Lordship observed, and I quote, "The future of our arbitration is not just international, it is also Indian," I unquote. If India is to realize this aspiration, it would require sustained efforts on the part of each one of us to build arbitral institutions that function with consistency, efficiency, and transparency. We profoundly welcome His Lordship, the Honorable Chief Justice of India, amidst us. We are truly honored by the presence of Honorable Shri Bhupendrabhai Patel, the Chief Minister of the State of Gujarat. Sir, under your leadership, there has been a significant improvement in the legal infrastructure of the state. The proposed arbitration building and the infrastructural projects, like the 4 new buildings presently under construction within the High Court campus, have been made possible with the active support of the state government. We welcome you, sir, on this occasion. We are deeply grateful for the presence of Honorable Mr. Justice Aravind Kumar, Judge Supreme Court of India. His Lordship, while serving as the Chief Justice of the Gujarat High Court, took several initiatives to strengthen the institutional framework of the Gujarat High Court Arbitration Center. I must place it on record that the idea of a new building for arbitration center was first mooted by His Lordship. We are just following the footsteps of your Lordship. Warm welcome to His Lordship. It is indeed our privilege to welcome Honorable Mr. Justice Nilevi Anjaria and Honorable Mr. Justice Vipul M. Pancholi, Judges, Supreme Court of India. The presence of their Lordship in the inaugural session and especially their participation in the technical and valedictory sessions is truly encouraging. Having them with us not only strengthen our efforts but also serve as a reassurance of their continued guidance and support. Thank you, Your Lordship. We heartily welcome Honorable Shri Harsh Singhvi, the young, dynamic Deputy Chief Minister and Cabinet Minister for Law and Justice, State of Gujarat. We are grateful for keen interest taken by him in each and every endeavor of the state judiciary. We warmly welcome all our distinguished guests whose presence on this occasion reflects the shared commitment of different institutions towards strengthening dispute resolution mechanisms. It is in this larger context that the need for promoting institutional arbitration assumes significance. Courts play a central role in adjudication of disputes. However, it is not possible nor suitable for every dispute to be resolved through the traditional court system. In this context, alternative dispute resolution mechanisms such as arbitration offers a valuable complement to the formal judicial process. Over the years, arbitration has increasingly become a preferred method of resolving commercial disputes. Businesses today look for dispute resolution processes that are efficient, reliable, and capable of preserving their ongoing relationships. There is a growing shift towards institutional arbitration as it provides structured processes, administrative assistance, and a dependable framework for dispute resolution. Establishing credible arbitration institutions has thus become an imperative for improving the overall effectiveness of the dispute resolution system in the country. It is with this objective that the Gujarat High Court established the Arbitration Center 4 years ago on 20th of February 2021 under the leadership of Honorable Mr. Justice Vikram Nath, the then Chief Justice of the Gujarat High Court. At present, the Arbitration Center is functioning from a makeshift building. The center has seen a slow and steady growth in the number of references. The center is arranging monthly meeting ranging between 150 to 170, both physical and in hybrid mode. The adoption of a hybrid model of mediation and arbitration with the establishment of India's first dedicated MEDARB Center on 15th August 2024 is an important step taken by the Center to strengthen the alternative dispute resolution institutions. The founder batch of 11 trained mediators, well versed in commercial matters, are rendering their pro bono service. Honorable the Chief Justice of India, Honorable Mr. Justice Surya Kant, while adorning the office of the Executive Chairperson of NALSA, has brought a mediation movement in the country with the Mediation for Nation campaign. Taking inspiration from His Lordship, a fresh batch of total 52, comprising of High Court lawyers and retired district judges, have been imparted 40 hours mediation training last week only, and they are ready for their induction. So far, 43 matters arising out of commercial suits and at the pre-referral stage of the arbitration, and 2 from NCLT have been referred for mediation in the MEDARB Center, 7 out of which have been settled with the effort of skilled mediators. Recently, the Center has resolved more than a decade-old commercial dispute at the stage of Section 37 arbitration appeal in just 2 mediation sittings, demonstrating the efficiency and potential of mediation. The construction of 3-storied building is a significant step to meet the growing needs of the center. The building is designed to house 16 arbitration conference halls, each equipped with 2 breakout rooms to facilitate confidential deliberations between parties and their counsels, and private chambers for arbitrators. On the third floor, 7 mediation rooms and facilities for online dispute resolution with a server room and workstations for legal assistant and staff attached with the center have been conceived. The building will stand as a testament to the commitment of the Gujarat High Court to strengthen ADR institutions. The center is also taking initiatives aimed at promoting greater awareness, accessibility, and engagement among all stakeholders associated with the process. The first edition of the newsletter of the Gujarat High Court Arbitration Center is a step towards greater transparency and outreach. The launch of redesigned, user-friendly website of the Arbitration Center is aimed at improving efficiency and accessibility. By facilitating display of cause list, regular updates regarding proceedings and institutional activities, we are planning to enable a secure electronic filing platform as well. The 2-day conference on the theme Institutional Arbitration at a Crossroads, Challenges and the Way Forward is organized to encourage a meaningful dialogue among the stakeholders, highlighting the need to identify procedural gaps and to take corrective measures, reinforcing the efficiency and credibility of institutional arbitration. In the technical sessions, we will be reflecting on the key aspects of structural, ethical, and practical challenges, trust deficit, capacity building, and need for a shift in the legal culture. The last session is focused on evolving hybrid models of MEDAB and ARB-MED. We are fortunate to have with us an eminent panel of speakers. Honorable Mr. Justice Nilay Anjaria, Honorable Mr. Justice Vipul Pancholi, Honorable Mr. Justice A.K. Sikri, Honorable Mr. Justice S.J. Wazifdar, former Chief Justice of the High Court of Punjab and Haryana High Court, Shri Janak Dwarka Das, Shri Shyam Diwan, and Dr. Bireen Saraf, senior advocates. We sincerely thank them for taking out their valuable time to engage with the participants. We are confident that sharing their experience in arbitration practices and adjudication in the discourse will greatly enrich the conference. I, on my behalf and on behalf of my brother and sister judges, express our sincere gratitude to Honorable Justice Surya Kant, the Chief Justice of India, Honorable Shri Bhupendrabhai Patel, the Chief Minister of the state, for their gracious presence, which has truly elevated this event. We extend our heartfelt regards to the distinguished dignitaries on and off the dais for their association with the program. I must express my heartfelt thanks to Honorable Mr. Justice A.Y. Kurje, the Executive Chairperson, Gujarat State Legal Services Authority and President of the Board of Governors of the Gujarat High Court Arbitration Center, and the members of the board for their invaluable guidance and meticulous planning in organizing this event. Special mention goes to Honorable Mr. Justice A.S. Supaiya, Chairperson, Building Committee, and its members, in bringing the vision of the state-of-the-art arbitration building into reality. I am deeply indebted to my esteemed brother and sister judges of the High Court of Gujarat for their unwavering support. Without their enthusiastic involvement at each stage of planning and execution, organizing such an event would not have been possible. I express my sincere gratitude to Mr. Kamal Trivedi, the Learned Advocate General, for his consistent support and guidance. Our sincere thanks to Mr. Yatin Oza, the President, Mr. Prithvi Raj Jadeja, the Vice President, the office bearers, and members of the Managing Committee of the Gujarat High Court Advocates Association, learned senior advocates, and learned members of the bar for their wholehearted participation. A special note of thanks to the advocates of the High Court, Mr. Kunal Vyas, Mr. Adit Sanjanwala, Mr. Arjun Joshi, Mr. Munjal Bhatt, Mr. Jaimin Dave, Mr. Kunal Vaishnav, Mr. Arjun Shet, Ms. Natasha Sutaria, Ms. Priyal Parekh, Mr. Ishan Joshi, Mr. Rohan Lavkumar, Mr. Anand Patel, Ms. Gargi Vyas, Mr. J. Kansara, whose assistance to the panelists during the technical session is vital to facilitating informed and productive deliberations. Our deep appreciation goes to Ms. Tanaya Shah and Mr. Harsh Parekh, advocates of the High Court, for undertaking the responsibility of the Master of Ceremony. We must place on record our sincere appreciation to the Registrar General of the High Court, Member Secretary Gujarat State Legal Services Authority, Director Gujarat High Court Arbitration Center, and their team for their exemplary coordination and organizing abilities shown in the planning and execution. We are truly encouraged by the overwhelming response of the participating advocates. Participation in the conference is by way of registration, and it is heartening to see that advocates from across districts have shown enthusiasm for engaging in all the technical sessions. This is a testament to our collective commitment and collaborative efforts in fostering the growth of ADR institutions across the state. I am confident that the deliberations during the conference will contribute meaningfully to strengthen institutional arbitrations and promoting best practices in dispute resolution. Together, we remain committed to building the ADR ecosystem in the state future ready. Thank you. Jai Hind.
Thank you, Your Ladyship, for the warm welcome address. Gujarat High Court, under the leadership of our Chief Justice, Honorable Mrs. Justice Sunita Agarwal, has taken an initiative to build a state-of-art domestic and international arbitration center within the precincts of the Gujarat High Court. The High Court of Gujarat is pleased to announce the establishment of its new arbitration center. The arbitration center is envisioned as a premier institution for the expeditious resolution of commercial and other disputes. The Gujarat High Court Arbitration Center will be a state-of-art facility equipped with modern infrastructure, including 16 arbitration rooms, 7 mediation rooms, 2 breakout rooms with each arbitration room, an online dispute resolution facility for making the infrastructure truly global in its reach.
Through this initiative, the Gujarat High Court reaffirms its commitment to fostering a robust dispute resolution ecosystem that inspires confidence, supports economic growth, and upholds the highest standards of justice, with parties having access to a distinguished panel of eminent arbitrators, mediators, and domain experts drawn from the diverse jurisdiction and fields of expertise. Let us now proceed with the foundation stone laying ceremony. Today marks not just the inauguration of a structure, but a realization of a vision, a commitment, and months of dedicated effort. As a part of the foundation stone laying ceremony, may we now request the dignitaries on the dais to unribbon the brick. As we gather here, we are reminded that buildings are made of bricks and mortar, institutions are built on values, dedication, and people. May this new facility serve generations to come and stand as a beacon of excellence and service. May we now invite the dignitaries on the dais to proceed to unveil the plaque. We will now be seeing a glimpse of the upcoming Gujarat High Court Arbitration Center building through an audio-visual representation.
Rising gracefully within the august precincts of the High Court campus, the new state-of-the-art building of the Gujarat High Court Arbitration Center is envisioned as a beacon of institutional excellence, harmonizing architectural elegance with functional sophistication. Fully air-conditioned and complemented by an integrated parking facility, the ground plus 3-story structure has been thoughtfully designed with provision for vertical expansion by 1 or 2 additional floors, ensuring readiness for future growth. Upon entry, visitors are greeted by spacious reception lounges on either flank, setting a tone of warmth and efficiency. The floor houses the chambers of the director and the deputy director, symbolizing the administrative heart of the center. Comfortable advocate waiting areas and a tastefully designed cafeteria offer spaces for informal interaction and repose, while the layout ensures intuitive navigation and accessibility. It accommodates the principal staff workspaces, designed for collaborative efficiency and quiet concentration. A well-appointed waiting lounge provides comfort for visitors, and a secure record and storage section ensures meticulous preservation of arbitral documentation and institutional archives. Spanning the first and second levels are 16 finely crafted arbitration halls, each designed to host proceedings with dignity and discretion, and each with a seating capacity of 23 persons. Every hall is complemented by a private rest area for the learned arbitrator and 2 dedicated breakout rooms to facilitate confidential consultations. Attached staff rooms, help desk facilities, and comfortable waiting lounges ensure that every stage of the arbitral process is supported by seamless institutional service. The third floor is devoted to mediation and next-generation dispute resolution. Purpose-designed mediation rooms embody calm, neutrality, and confidentiality, creating an atmosphere conducive to dialogue and settlement. Offices and workspaces for the private secretary and legal assistants are thoughtfully integrated, ensuring proximity to the center's core functions. The floor also houses a dedicated online dispute resolution room equipped for virtual proceedings and a secure, high-capacity server room forming the technological backbone of the center. At the uppermost level, A spacious multi-purpose hall offers versatility for conferences, training programs, and institutional events. Across every level, pantry facilities are provided to support extended deliberations with convenience and comfort. The building as a whole reflects a refined blend of serenity, efficiency, and technological readiness, an architectural expression of the Gujarat High Court Arbitration Centre's commitment to modern, responsive, and world-class dispute resolution.
The design perfectly captures the values of integrity, neutrality, and professionalism. A logo is more than just a visual symbol. It carries our identity, our values, our history, and our aspirations. Over time, as organizations grow and evolve, it becomes essential to ensure that our identity reflects our vision for the future. May we now request the Chief Justice of India, Honorable Mr. Justice Surya Kant, to unveil the new logo of the Gujarat High Court Arbitration Centre.
This concept presents GHAC as a robust, court-governed, modern arbitration institution encompassing a hybrid model of dispute resolution. The three interconnected abstract forms represent the mediator and the two disputing parties, visually expressing dialogue, balance, and guided resolution. Their triangular arrangement symbolizes stability and structured legal process. The surrounding laurel wreath reinforces institutional dignity, judicial honor, and official recognition. The three stars positioned above the emblem represent the core values of justice, integrity, and transparency, reflecting the center's guiding principles. The blue color palette has been intentionally chosen to communicate trust, reliability, and professionalism, aligning the identity with established judicial and governmental institutions. Overall, this concept conveys strength, neutrality, and the authoritative presence of a high court-backed arbitration center.
Thank you, Your Lordship. May we now request the Chief Justice of India, Honorable Mr. Justice Surya Kant, to launch the redesigned website of the Gujarat High Court Arbitration Centre. Obliged, Your Lordship. May we now request all the dignitaries on the dais to release the newsletter. Grateful. May we now request the Chief Minister of Gujarat, Honorable Shri Bhupendrabhai Patel, to give an occasional address.
ગુજરાત હાઈકોર્ટના આર્બિટ્રેશન સેન્ટરના ભૂમિપૂજન કાર્યક્રમમાં આપણી સૌની સાથે મંચ ઉપર ઉપસ્થિત સુપ્રીમ કોર્ટના માન્ય મુખ્ય ન્યાયાધીશ શ્રી સૂર્યકાંતજી, સુપ્રીમ કોર્ટના માન્ય ન્યાયાધીશ શ્રી અરવિંદ કુમારજી, શ્રી એનવી અંજારિયાજી, શ્રી વીએમ પંચોલીજી, ગુજરાત હાઈકોર્ટના માન્ય મુખ્ય ન્યાયાધીશ શ્રીમતી સુનીતા અગ્રવાલજી, મારા સાથી નાયબ મુખ્યમંત્રી શ્રી હર્ષભાઈ સંઘવી, ગુજરાત હાઈકોર્ટના માન્ય ન્યાયાધીશ શ્રી એ.વાય. કોગજીજી, શ્રી એ.એસ. સુપૈયાજી, રાજ્યના મુખ્ય એડવોકેટ જનરલ શ્રી કમલ ત્રિવેદીજી, આમંત્રિત સર્વે મહાનુભાવો, પ્રેસ મીડિયાના મિત્રો, સૌને મારા નમસ્કાર. વિશ્વ નેતા અને યશસ્વી વડાપ્રધાન શ્રી નરેન્દ્રભાઈ મોદીએ ન્યાય પ્રક્રિયા સરળ અને ઝડપી બને તે માટે અનેક પરિણામદાયી પ્રયાસો આદર્યા છે. જરૂરી માનવબળ અને ઇન્ફ્રાસ્ટ્રક્ચરના વિકાસથી ન્યાય પ્રક્રિયામાં તેમના નેતૃત્વમાં સુધારાઓ થઈ રહ્યા છે. એ સંદર્ભમાં ગુજરાત ન્યાયતંત્ર આ માટે આજે ઐતિહાસિક દિવસ છે. ગુજરાત હાઈકોર્ટ એડમિનિસ્ટ્રેશન સેન્ટરના નવા અદ્યતન ભવનના શિલાન્યાસ પ્રસંગે આપ સૌ ન્યાયવિદ સાથે ઉપસ્થિત રહેવાની મને પણ તક મળી છે. વડાપ્રધાનશ્રીએ ભારતને ગ્લોબલ આર્બિટ્રેશન હબ બનાવવા માટે સ્પેશિયલ આર્બિટ્રેશન અને બાર એસોસિએશનની વ્યવસાયિક સહભાગિતાની જરૂરિયાત પર ભાર મૂક્યો છે. ભારતમાં એડમિનિસ્ટ્રેશનની પરંપરા નવી નથી. ઉપનિષદમાં વિવિધ પ્રકારની મધ્યસ્થી સંસ્થાઓનું વર્ણન પણ છે. એમાંય પંચાયતી પ્રણાલીમાં પંચ પરમેશ્વરની ભાવનાના આધારે વિવાદોનું નિરાકરણ થતું હતું. ઉત્તરોત્તર આર્બિટ્રેશનમાં કાયદાકીય સુધારા થતા ગયા અને હાલ 2021ના મહત્વપૂર્ણ સુધારાઓ અમલમાં છે. આજના પ્રસંગે આપણે પૂજ્ય મહાત્મા ગાંધીજીને પણ યાદ કરવા પડે. દક્ષિણ આફ્રિકામાં વકીલાત દરમિયાન તેમણે કાયદાકીય લડાઈ કરતા સમાધાનને પ્રાથમિકતા આપી હતી. પૂજ્ય બાપુ માનતા હતા કે વકીલોનું સાચું કાર્ય બે વિભાજિત પક્ષોને એક કરવાનું છે. આ વિચારધારા જ આજની આર્બિટ્રેશન સિસ્ટમનું હાર્દ છે એમ હું સમજુ છું. આદરણીય વડાપ્રધાનશ્રીના દિશાદર્શનમાં 75 વર્ષ ઉજવ્યા છે. લોકતંત્રનું સાચું બળ મજબૂત અને પારદર્શક ન્યાયતંત્રમાં છે અને બંધારણ આપણને કાયદા સમક્ષ સમાનતા અને ન્યાય મેળવવાનો અધિકાર આપે છે. દેશના દરેક નાગરિકને સામાજિક, આર્થિક અને રાજકીય ન્યાય અપાવવાનો સંકલ્પ બંધારણમાં છે. ન્યાયી પ્રક્રિયા માત્ર કોર્ટરૂમમાં ચાલતી કાર્યવાહી નથી, પરંતુ તે નાગરિકોના અધિકારોની રક્ષા કરતું, પારદર્શિતા અને જવાબદારી સુનિશ્ચિત કરતું એક જીવંત તંત્ર છે. સામાન્ય નાગરિકને ઝડપી અને સગવડ ભર્યા ન્યાય મળે તે માટે સૌ માટે ન્યાય, સમયસર ન્યાય એવા સ્પષ્ટ અભિગમ સાથે ગુજરાતમાં ઈ કોર્ટ, ડિજિટલ કેસ મેનેજમેન્ટ અને વર્ચ્યુઅલ હિયરિંગ જેવી વ્યવસ્થાઓને પ્રોત્સાહિત કરી છે. રાજ્ય સરકાર ન્યાયિક માળખાકીય સુવિધાઓને મજબૂત બનાવવા પ્રતિબદ્ધ છે. નવી કોર્ટ ઇમારતો, ટેકનોલોજી આધારિત સુવિધાઓ જેવી ફેસિલિટીઝ વધારતા જઈ રહ્યા છે. આ વર્ષે બજેટમાં પણ આ વિભાગ માટે 2700 કરોડ રૂપિયાની રકમની જોગવાઈ કરી છે. અહીં નવા બનનાર સ્ટેટ ઓફ ધી આર્ટ આર્બિટ્રેશન સેન્ટરના શિલાન્યાસની સાથે સાથે લોગો અને નવી વેબસાઇટ પણ લોન્ચિંગથી આ આર્બિટ્રેશન સેન્ટરની નવી ઓળખ ઊભી થશે. ગુજરાત વેપાર, ઉદ્યોગ અને વૈશ્વિક રોકાણનું અગ્રીમ રાજ્ય છે. વેપાર અને ઔદ્યોગિક પ્રવૃત્તિઓ વધે તેમ વિવાદ પણ ઊભા થતા હોય છે. પરંપરાગત અદાલતી પ્રક્રિયાઓમાં સૌને ન્યાય અપાવવા લાંબો સમય જતો હોય, તેથી ઝડપી અને કાર્યક્ષમ વિવાદ નિવારણ માટે વૈકલ્પિક વ્યવસ્થા અનિવાર્ય બની છે. આર્બિટ્રેશન અને મીડિયેશન જેવી પદ્ધતિઓ ઇઝ ઓફ ડુઇંગ બિઝનેસને મજબૂત આધાર પૂરો પાડે છે. આ સ્ટેટ ઓફ ધ આર્ટ આર્બિટ્રેશન સેન્ટરથી મધ્યસ્થી પ્રક્રિયાઓને નિષ્પક્ષ, પારદર્શક અને સરળ બનાવવાનો આપણો સંકલ્પ છે. અહીં નિર્માણ થનારી આ નવી ઇમારતની વિશ્વ સ્તરીય સુવિધાઓથી વકીલો, મધ્યસ્થીકારો અને પક્ષકારોની કાર્યક્ષમતા વધશે. વડાપ્રધાન શ્રીના 2047ના ભારતને વિકસિત રાષ્ટ્ર બનાવવાના સંકલ્પ માટે મજબૂત અને સ્વતંત્ર ન્યાયપાલિકા અનિવાર્ય અંગ છે. ઇન્સ્ટિટ્યુશનલ આર્બિટ્રેશન એટ એ ક્રોસરોડ, ચેલેન્જીસ એન્ડ ધ વે ફોરવર્ડ થીમ સાથે આજે શરૂ થઈ રહેલી 2 દિવસીય કોન્ફરન્સ પણ તેમાં દિશાદર્શક બનશે. આ કોન્ફરન્સને સફળતાની શુભેચ્છાઓ પાઠવીને વિરમું છું. ભારત માતા કી જય. વંદે માતરમ. જય જય ગરવી ગુજરાત.
Thank you, sir, for your occasional address. Your continued support to this vision will ensure that Gujarat becomes a hub for domestic and international arbitration. May we now request the Chief Justice of India, Honorable Mr. Justice Surya Kant, to offer an inaugural address.
Shri Bhupendrabhai Patel, Honorable Chief Minister of Gujarat, my esteemed colleagues from the Supreme Court of India, Justice Aravind Kumar, Justice Nilay Vipin Chandra Anjaria, Justice Vipul Pancholi, my sister Justice Sunita Agarwal, Honorable Chief Justice of Gujarat High Court, Shri Sanghavi, Honorable Deputy Chief Minister of Gujarat, we have among us Justice A.K. Sikri, Justice M.R. Shah, Honorable former judges of the Supreme Court, Justice K.S. Jhaveri, Justice Sonia Ben Gokani, Honorable the former Chief Justices of Odisha and Gujarat High Court respectively, my sister and brother judges from the Gujarat High Court, led by Justice Alpesh Kogze and Justice Aravind Sufaya on the dais, Shri Kamal Trivedi, Learned Advocate General Gujarat, former judges of the Gujarat High Court, eminent senior advocates representing the Supreme Court, Bombay High Court, Sarv Shri Shyam Diwan, Shri Janak Dwarkadas, a galaxy of senior advocates from the Gujarat High Court Bar Association, a dynamic young leader of the Bar, Shri Jadeja, President of the Gujarat High Court Bar Association, and his entire team of executive members and office bearers, distinguished members of the Gujarat High Court Bar, distinguished academia, arbitrators, mediators, members of the legal fraternity, representatives of the institutions, friends from media, ladies and gentlemen. Very good morning to all of you. I'm happy to be here today to mark 2 occasions that are in essence expression of a single purpose: the inauguration of a new institutional space and the commencement of a deeper conversation on the future of institutional arbitration in India. One is an act of stone and mortar. The other is an act of reflection. These are not routine ceremonial engagements placed side by side on a program. They represent 2 decisive steps in a shared journey, one giving concrete force to our commitment, the other providing intellectual directions. Together, they affirm a shared resolve, namely that India's dispute resolution framework should not merely function but inspire confidence, just not merely exist but command trust. Shortly before this event, here only, we laid the foundation stone of a new state-of-the-art building of the Gujarat High Court Arbitration Center. And I want to pause and spend a moment on what it truly signifies. It would be easy to treat the construction of a building as a merely administrative matter, a question of roof and rooftops along with rooms. But physical spaces speak before words are exchanged. They communicate to every party who walks through the door whether they will be taken seriously, whether the process they are entering is credible, and whether the institution standing behind that process is worthy of their trust. Allow me, therefore, to begin by reflecting on what we inaugurate today in its tangible form and what it signifies beyond it. Ladies and gentlemen, institutional trust is not only shaped by principles, but by tangible realities also. I have long held the view that spaces influence conduct. When parties enter an arbitration facility that is ordered, professional, and purpose-built, the proceedings acquire a distinct seriousness. When arbitrators preside in an environment that affirms the dignity of the process, it fosters a heightened sense of responsibility. Infrastructure, therefore, is not merely an amenity, it is an institutional signal. And today, the Gujarat High Court Arbitration Center sends that signal with clarity and conviction. When a party, whether a small domestic enterprise or a sophisticated international investor, steps into a carefully conceived arbitration facility, they encounter something that a converted conference room or a borrowed courtroom cannot provide: the unmistakable signal that their dispute matters. Dedicated hearing halls, mediation facilities, digital infrastructure, spaces designed to protect confidentiality, these are all not luxuries. They are the physical expressions of institutional seriousness. And as you have seen in the video, I'm quite happy to note that the proposed arbitration center addresses all these issues. I believe that a modern arbitration center reflects predictability, organization, and seriousness of purpose. It communicates that proceedings will be conducted with care, neutrality, and procedural rigor. In commercial matters, where time is capital and certainty is currency, such signals matter deeply. By creating a dedicated and well-equipped arbitration complex, the Gujarat High Court Arbitration Center reinforces the idea that institutional arbitration in India is prepared to meet global standards. Today also marks the launch of the redesigned Gujarat High Court Arbitration Center website. In the contemporary landscape, digital infrastructure is no longer supplementary to institutional arbitration. It has become foundational to its effectiveness and credibility. Secure online filing, the ability to conduct virtual hearings, and real-time access to information enable arbitration to remain accessible, efficient, and responsive regardless of geographical barriers. Alongside this, the release of the Gujarat High Court Arbitration Center newsletter represents a thoughtful step towards strengthening awareness of institutional arbitration and other alternative dispute resolution mechanisms. The sharing of knowledge and best practices is not peripheral to institutional building, it lies at its very core. These developments are not ends in themselves. They are part of a larger institutional journey. It is therefore fitting that we now turn to the theme of the conference that begins today, namely the institutional arbitration at the crossroads, challenges, and the way forward. The phrase is deliberately candid, inviting both candor and intellectual honesty. We are indeed at the crossroads, and we must speak with clarity about what each path holds. We have assembled here to examine with clear eyes where institutional arbitration in India stands today and what it must become in the years ahead. I believe you will also keep in mind the very eminent issue flagged by Honorable Chief Minister when he pointed out that how Gujarat is leading the nation in terms of industrial development and technological advancement, and the all sophisticated and hard industries are coming to this state, and how conventional litigation may not be the real response to the foreign investors, and therefore how institutional arbitration acquires a special importance in our legal and jurisdictional framework. I therefore must acknowledge that India's arbitration framework has by now matured considerably. Legislative reforms to the Arbitration Act have emphasized minimum judicial intervention, time-bound proceedings, and neutrality in appointments. Parallelly, judicial pronouncements have reinforced party autonomy and clarified doctrinal uncertainties. Yet, this progress does not eliminate challenges. Institutional arbitration in India still occupies a space smaller than it ought to be. A substantial volumes of disputes continues to proceed through ad hoc mechanisms. Our institutional arbitration disputes have their preferred destinations outside India. The question we must confront is not whether arbitration is viable. The question is, it is whether our institutional arbitration and our institutions meant for that inspire sufficient trust to become the most preferred choice and destination. In understanding that, I want to briefly ponder the challenges which frequently occur in institutional arbitration. The first challenge is trust. Institutional arbitration fulfills its promise only when users genuinely trust it. Trust in the neutrality of arbitrator appointments, trust in procedural integrity, trust in the enforcement of awards. That trust is not built by rules on paper. It is built through consistent, transparent, and demonstrably fair practice over time. We must ask honestly whether our institutions have yet earned that trust in full and what more they must do to earn it. The second challenge is capacity. The number of institutional arbitrations in India remains disproportionately small relative to the volume of commercial disputes our country generates. Too many parties still default to ad hoc arbitration or to courts because institutions have not sufficiently demonstrated the value they add. Expanding institutional capacity in infrastructure, in impaneled arbitrators, in case management systems, in administrative competence is therefore not a question of prestige, it's a question of relevance. The third and most consequential, as it perhaps appears to me, is the challenge of professionalization. Arbitration at its finest is a specialized discipline. It demands not only legal acuity, but case management skills, sensitivity to cross-border commercial realities, and an understanding of what is genuinely at stake for the parties. India must invest seriously in training arbitrators and in developing a coherent pipeline of qualified arbitral professionals. Without that investment, growth in the number of institutions will outpace growth in the quality of the process, and the gap between form and substance will only widen. The way forward, in my opinion, lies in institutional honesty. We must be willing to measure ourselves not against where we begin, but against where we need to be, against the standards of the leading arbitral seats of the world, and against the legitimate expectations of parties who choose arbitration in the hope of something better and faster than litigation. As I look at the ground we have consecrated today, I am reminded that every institution we now respect, every court that commands genuine confidence, was once no more than a vision led by people willing to act on it. What separated vision from institution was not resources alone, it was resolve. The sustained, unglamorous resolve to keep building when the work was slow and the results were uncertain. Today's foundation stone carries that resolve. So does this conference. I hope that over the next 2 days, we deliberate not merely to diagnose, but to prescribe with the clarity, candor, and courage that this moment demands. The doors of a new building will soon open. Let us ensure that what walks through those doors is a stronger, more trusted, and more capable system of institutional arbitration, one that our country and every party who approaches it genuinely deserves. Thank you very much for inviting me and giving this opportunity to share my views. Jai Hind, Jai Bharat.
Obliged, Your Lordship. Your Lordship's dedication to strengthening and promoting alternative dispute resolution mechanism reflects remarkable vision and leadership. We are reminded of your words where you said, when we consider these issues and challenges, we must understand that these are not insurmountable obstacles, but reminders of discipline required to safeguard arbitral integrity. May we now request Honorable Mr. Justice A.Y. Kokje, Judge, High Court of Gujarat, to offer vote of thanks.
Namaste and very good morning. Dignitaries on the dais, Honorable Mr. Justice Surya, Chief Justice of India, Shri Bhupendrabhai Patel, respected Chief Minister of State of Gujarat, Honorable Mr. Justice Aravind Kumar, Honorable Mr. Justice N.V. Anjaria, Honorable Mr. Justice Vipul Pancholi, Judges of the Supreme Court of India, Shri Sanghavi, respected Deputy Chief Minister, Honorable Ms. Justice Sunita Agarwal, the Chief Justice of Gujarat High Court, Brother Justice Supaiya, Judge of Gujarat High Court and Chairperson of Gujarat High Court Legal Services Committee, my sister and brother judges, Shri Kaushik Vekaria, respected Minister of State, Law and Justice, State of Gujarat, in absentia, Learned Advocate General, Shri Kamalbhai Trivedi, former Honorable Judges of the Supreme Court of India, former Honorable Chief Justices and Judges of different High Courts, Learned Government Pleader, Gujarat High Court, Shri Virk, Learned Public Prosecutor, Shri Hardik Dave, Shri Yatin Oza, President Gujarat High Court Advocate Association, along with his team members, Shri Arbitrator registered with the Gujarat High Court Arbitration Center, senior members of the bar, Learned Registrar General, members of the registry, learned advocates from various bar associations, invitees, media persons, ladies and gentlemen. It is a matter of great honor for me to propose vote of thanks on today's occasion being milestone in the arbitration movement within the state of Gujarat when we celebrate the foundation stone laying ceremony of new state-of-art building, the Gujarat High Court Arbitration Center, international and domestic, at the hands of the dignitaries present. On behalf of Gujarat High Court, as also on my behalf, I express deep sense of gratitude towards Honorable the Chief Justice of India, who has agreed to be amongst us on this important event, which also marks the beginning of 2 days conference, the institutional arbitration at the crossroads, challenges and way forward. Presence of Honorable the Chief Justice of India assumes importance, as Honorable the Chief Justice of India himself has been great advocate of alternative dispute resolution system. I hope and pray that the Lordship visits to our state is meaningful and comfortable. I must thank Honorable Chief Justice of Chief Minister of Gujarat, Shri Bhupendrabhai Patel, who is always in the forefront whenever it comes to supporting judiciary in whatever manner. We thank him and his government for supporting our project in setting up this arbitration center. I also take this opportunity to thank Honorable Mr. Justice Aravind Kumar, Honorable Mr. Justice N.V. Anjaria, and Honorable Justice Vipul Pancholi, judges of the Supreme Court of India, who have taken time out of their schedule to be amongst us on this important event. We all know that honorable judges have been closely associated with Gujarat High Court and have always blessed with their good wishes to any venture which the High Court would take up in the directions of development of judiciary, which includes alternative dispute resolution. On this occasion, let me congratulate and thank our Chief Justice, Justice Sunita Agarwal, who has envisioned the state-of-art arbitration center and tirelessly worked to make this center a center of professionalism. And in making such effort, Honorable the Chief Justice of Gujarat High Court has always guided Gujarat High Court in undertaking conferences focusing on the capacity building of the stakeholders. I also thank my brother Judge Justice Supaiya and all my sister and brother judges who have stood by the institution by treating the event as their own and making it successful. I acknowledge the presence of Honorable Deputy Chief Minister Shri Sanghavi, who has always looked forward to support the cause of judiciary. I myself, being a sportsperson, take this opportunity on behalf of all present to congratulate Harshbhai, who made extraordinary efforts to get 2029 World Police and Fire Games and back-to-back 2020 Centenary Commonwealth Games to the city of Ahmedabad as host. His effort needs to be. I also take this opportunity to acknowledge contribution of Shri Hon'ble Trivedi, Learned Advocate General, and Shri Soparkar, Learned Senior Advocate, who are the esteemed members of the Board of Governors of Arbitration Center and who have been present from day one of planning of this event. I extend my gratitude towards the Registrar General and the members of the registry who have worked tirelessly and contributed towards the success of this event. I acknowledge the support of electronic and print media for giving the weightage to our efforts in the direction of alternative dispute redressal. I must acknowledge in absentia the contribution of the contributors of the articles which have found place in the newsletter and also reference material for the 2 days conference. For this, I must thank Brother Justice Karya and his team of Judicial Academy for carefully compiling the reference material. I must profusely thank our resource persons and the assisting advocates who are going to be focal point for next 2 days. I thank all the invitees, which include honorable former judges of the Supreme Court and the High Court, empaneled arbitrators, mediators, learned advocates from various bars. Thank you for your esteemed presence. We hope that this conference would turn out to be effective with your meaningful participation. I thank all the participants from bottom of my heart for overwhelming registration for the conference. I may inform the gathering that for inaugural session and technical sessions, we have participation of 1,300 participants. Thank you all. Jai Hind.
Oblige my lords for the vote of thanks. Apuryamaणम achala pratishtham samudra mapa pravishanti advat Tadvat kamayam pravishanti sarve sashanti mapnoti na kama kami. Just as the ocean remains steady and undisturbed, though countless rivers flow into it, may this conference remain rooted in wisdom and values. As streams of knowledge, ideas, and aspirations flow into it, leading us all towards excellence and fulfillment.
With this, we now conclude the inaugural session. May we request everyone to stand in respect for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We may now proceed for a tea break. Honorable dignitaries are requested to proceed for refreshments. In the meantime, may we request other participants to remain seated till the departure of honorable dignitaries.
So that we can start the session on time. बोला है तुम
We once again request all participants and guests to please take their seats. We once again request all participants and guests to please take their seats.
बोला you all are requested to cooperate to ensure that our proceedings start on time. You all are requested to take your seats. नीचे आ जाता रहो नीचे आ जाता रहो
એવું કરું છે
ચાલશે ખરાબ લાગશે
મેં કહ્યું આપણે
ખરાબ લાગે
એટલે કહ્યું આપણે તો
We are about to start the session. The guests and participants are requested to take their seats. Hello everyone, welcome back. The topic for the first session is an introductory reflection of institutional arbitration. While discussing this topic, we will endeavor to discuss the concept and framework of institutional arbitration and comparison between institutional and ad hoc arbitration. At this juncture, while we are at a crossroad where there's a trust deficit in institutional arbitration, we will endeavor to explore the solution and a way forward. The esteemed speakers for this session are Honorable Mr. Justice Vipul M. Pancholi, Judge, Supreme Court of India, and Honorable Mr. Justice A.K. Sikri, former Judge, Supreme Court of India, and presently Judge, Singapore International Commercial Court.
It is a privilege to introduce the speakers for the first session. Honorable Mr. Justice Vipul M. Pancholi, Judge, Supreme Court of India. Enrolled at the bar in 1991, Justice Pancholi built a substantial and diverse practice before the Gujarat High Court, appearing in matters spanning constitutional law, civil and criminal litigation, banking, property, and service law. He also served as assistant government pleader and additional public prosecutor, combining advocacy with public responsibility. Alongside his practice, he contributed meaningfully to legal scholarship and education, serving as honorary joint editor of the Gujarat Law Herald and teaching law for over 2 decades at the Sir L. A. Shah Law College. This rare blend of courtroom experience and academic engagement has consistently enriched his judicial approach. Elevated to the bench of the Gujarat High Court in 2014 and confirmed as a permanent judge in 2016, he later served at the Patna High Court, where he was appointed Chief Justice in July 2025. Shortly thereafter, he was elevated to the Supreme Court of India in August 2025. His Lordship, while sitting judge of the Gujarat High Court, had delivered a landmark judgment in the case of MV Cape Climbers versus Global Wealth Shipping Private Limited concerning a foreign arbitral award, where his Lordship rules in favor of enforcement of the award, rejecting a technical plea against the enforceability of the award, thereby reinforcing a pro-enforcement approach embodied in the Arbitration and the Conciliation Act. His background in commercial law and his wide judicial experience naturally resonate with the principles that underpin arbitration: neutrality, efficiency, respect for party autonomy, and fidelity to legal doctrine. In a time when the interface between courts and arbitral tribunals continues to evolve, his insights are especially valuable to the arbitration community. We are deeply honored by his presence and look forward to the wisdom he brings to our deliberation.
Before we introduce the next speaker, may we request the honorable speakers for this session, Mr. Justice V.M. Pancholi, Judge, Supreme Court of India, and Honorable Mr. Justice A.K. Sikri, former Judge, Supreme Court of India, to please come on the stage. Thank you, Tanaya, for the introduction of Justice Pancholi. Honorable Mr. Justice A.K. Sikri, former Judge of the Supreme Court of India, and currently an international judge of the Singapore International Commercial Court, is known to all of us. Justice Sikri was elevated to the Supreme Court in 2013, and after serving as Chief Justice of the Punjab and Haryana High Court and Judge of the Delhi High Court. A distinguished judicial career, he's authored nearly 2,000 reported judgments, including more than 200 in commercial and arbitration law. In arbitration jurisprudence, he has delivered landmark decisions that continue to shape Indian arbitral law. In the case of A. Ayaswamy versus A. Paramasivam, he clarified that mere allegations of fraud cannot be used to avoid arbitration, and that only serious and complex allegations justifying criminal adjudication would warrant reference, a rule that has strengthened the pro-arbitration approach of Indian courts. In the case of Jayaprakash Associates with Tehri Hydro Development Corporation, he reaffirmed that an arbitrator cannot avoid parental interest where the contract expressly prohibits it, underscoring the centrality of party autonomy under the Act. Since retirement, Justice Sikri continues to contribute actively as a presiding and sole arbitrator in domestic and international arbitrations, bringing to the process both judicial depth and practical arbitral experience. Without much ado, we take the session forward and invite our guests to please proceed with the discussion.
Honorable Mr. Justice A.K. Sikri, former Judge Supreme Court of India, my sister and brother judges of Gujarat High Court, Mr. Sham Diwan, learned senior advocate of Supreme Court of India, other distinguished dignitaries of the dais, all the esteemed participants gathered here today, learned senior advocates, ladies and gentlemen, good afternoon. It is my profound privilege and honor to stand before you at this landmark conference on institutional arbitration at a crossroad, challenges and the way forward. I extend my heartfelt gratitude to the Honorable Chief Justice of the Gujarat High Court for her visionary leadership in organizing this two-day deliberation. This conference represents not merely an academic exercise, but a critical examination of the very foundation upon which we build our dispute resolution mechanism in this nation. Today, in this first session, we embark on an introductory reflection that will set the stage for the deeper discussion that follow. We will explore three fundamental aspects. First, the concept and framework of institutional arbitration. Second, the comparative analysis between institutional and ad hoc arbitration. And third, the crossroads moment we face today, characterized by issues of trust deficit, capacity constraints, and cultural challenge. Allow me to address first two aspects. I have divided this particular topic in different parts. The first one is slide number 1, Mr. What is arbitration? I have divided into these different parts. What is arbitration? What is ad hoc arbitration? Institutional arbitration, concept and framework. What is emergency arbitration? And the difference between institutional arbitration and ad hoc arbitration. Now, so far as the first aspect is concerned, here young advocates are also sitting here. Gana district માંથી બી young advocates આવ્યા છે, junior advocates આવ્યા છે. તો વચ્ચે વચ્ચે થોડું ગુજરાતીમાં પણ બોલી લઈશ કે જેથી એમને પણ ખ્યાલ આવે. Now, what is arbitration? It is essential to understand the very essence of arbitration as a dispute resolution mechanism. Arbitration at its core is a consensual process. It is born out of agreement between parties who choose to resolve their disputes outside the traditional court system. This consensual nature distinguishes arbitration from litigation and forms the bedrock of its legitimacy. The fundamental characteristics that define arbitration are manifold. First, it is a creature of contract. Parties submit to arbitration not by force of law, but by their mutual agreement. Second, it is a private process offering confidentiality that court proceedings cannot guarantee. Third, it promises finality. The arbitral award is binding and enforceable with limited grounds for judicial intervention. Fourth, it offers party autonomy, allowing disputants to choose their adjudicators, determine the procedure, select the governing law, and even decide the seat and language of arbitration. These characteristics make arbitration particularly attractive for commercial disputes, especially those of an international nature. In an era of globalization, where commercial transactions go beyond national boundaries, the need for a neutral, efficient, and enforceable dispute resolution mechanisms becomes paramount. Arbitration fulfills this need by offering a middle ground between the legal systems of different jurisdictions. The evolution of arbitration in India, next slide. Evolution of arbitration in India reflects a gradual shift from court-controlled dispute resolution to a modern institution-based framework. Globally, the establishment of the International Chamber of Commerce in the 1919, followed by creation of International Court of Arbitration in 1923, marked the rise of institutional arbitration worldwide. In India, arbitration was initially governed by the Arbitration Act of 1940, which was criticized for excessive judicial interference. The adoption of the New York Convention 1958 strengthened the international enforceability of arbitral awards. A major reform came with the Arbitration and Conciliation Act of 1996, based on the UNCITRAL model law, which modernized Indian arbitration law and aligned it with global standards, promoting institutional arbitration and minimizing court intervention. Next. Now, what is the meaning of ad hoc arbitration? To appreciate the distinction between institutional and ad hoc arbitration, we must first understand what ad hoc arbitration entails. Ad hoc arbitration is arbitration conducted without the administrative supervision or subject of an arbitral institution. The parties in the arbitral tribunal themselves manage the entire arbitration process from the constitution of the arbitral tribunal to the rendering of the award. In ad hoc arbitration, parties have complete freedom to design their own procedural framework. They can agree on rules tailored to their specific dispute, choose their own mechanisms for appointing arbitrators, determine how the arbitration will be conducted, and establish their own timelines and procedures. This flexibility is often seen as the primary advantage of ad hoc arbitration. Many parties conducting ad hoc arbitration adopt UNCITRAL arbitration rules as their procedural framework. These rules developed by UNCITRAL provide comprehensive set of procedures specifically designed for ad hoc arbitration. The UNCITRAL rules have gained wide acceptance and are regularly updated to reflect evolving arbitration practices. Ad hoc arbitration has a long and distinguished history Indeed, historically, most international arbitrations were conducted on ad hoc basis. Many landmark arbitrations, including significant investor-state disputes, have been conducted ad hoc. The approach continues to be popular in certain contexts, particularly in investment treaty arbitrations and in some domestic settings where parties prefer maximum flexibility and autonomy. Next. Now, what is institutional arbitration? Institutional arbitration has its roots in the recognition that while party autonomy is fundamental to arbitration, parties often need structured support to navigate the arbitral process effectively. The concept emerged from the practical challenges faced in ad hoc arbitrations, where parties, while free to design their own procedures, often encounter difficulties in case management, appointment of arbitrators, and procedure administration. Historically, the development of institutional arbitration can be traced to the establishment of arbitral institutions in commercial centers around the world. The International Chamber of Commerce (ICC), established in 1923, created its Court of Arbitration, which became pioneer model for institutional arbitration globally. Following this, various jurisdictions established their own arbitral institutions, recognizing the value of organized rule-based arbitration processes. In India, the journey toward institutional arbitration has been gradual but significant. While arbitration has been part of our legal framework since colonial times, the institutional framework remained underdeveloped for decades. The enactment of the Arbitration and Conciliation Act of 1996 marked a watershed moment, aligning Indian arbitration law with UNCITRAL model law. However, the growth of arbitral institution took longer to materialize. Today, we witness a revolution in Indian arbitration with establishment of various arbitral institutions. Mr. Next slide. Next slide. Next. Next slide. Next one, mister. Next one. No, prior to that. Now, today, there are different arbitration centers in India, which are firstly situated in Mumbai. One is at Delhi. So we witness a revolution in Indian arbitration with the establishment of various arbitral institutions, including Mumbai Center of International Arbitration, MCIA, Delhi International Arbitration Center, DIAC, and importantly, the arbitration centers established by various high courts, including the Gujarat High Court. These institutions represent India's ambition to become a preferred seat of international arbitration. Now, what is the concept and framework of this institutional arbitration? An arbitral institution is not merely an office that administers cases. It is a comprehensive ecosystem comprising several critical components that work in harmony to facilitate efficient dispute resolution. Understanding this architecture is essential to appreciate the value proposition of institutional arbitration. Now, there are different rules, institutional rules. At the heart of any arbitral institution lies its arbitration rules. These rules provide a comprehensive procedural framework that governs the conduct of arbitration administered by the institution. Well-drafted rules cover every stage of the arbitral process, from the commencement of proceedings to the rendering and correction of the awards. The rules typically address crucial aspects such as the procedure for filing requests for arbitration, mechanism for appointing arbitrators, provision for challenging arbitrators, timelines for various procedural steps, the conduct of hearings, the power to grant interim measures, provisions for summary disposal, and the procedure for rendering awards. These rules represent the collective wisdom and best practices distilled from years of arbitration experience worldwide. The beauty of institutional rules lies in their default applicability. When parties agree to arbitrate under the rules of a particular institution, they incorporate these comprehensive procedures into their arbitration agreement. This saves parties from having to negotiate procedural details at the outset or worse during the heat of a dispute. It provides certainty and predictability, knowing that a tested procedural framework will govern their arbitration. Now, administrative support is also required. One of the most tangible benefits of institutional arbitration is the administrative support provided throughout the arbitral process. The institution's secretariat acts as the backbone of case management, ensuring smooth operation of arbitral proceedings. This administrative function encompasses several activities. The institution manages case registration and file creation, maintains custody of all case documents, facilitate communications between the parties and the arbitrators, handles scheduling of hearings and procedural conferences, manages financial aspects including fee deposits and disbursement, provides logistic support such as hearing rooms and technological infrastructure, and maintains record of proceedings. આજે આપણે હમણાં સવારના વિડીયો જોયો ને, આપણું નવું સેન્ટર કેવું બનવાનું છે. એમાં આપણે દરેક જગ્યાએ જોયું કે આ રૂમ્સ હશે, વેટિંગ માટે શું હશે, હિયરિંગ માટે કઈ રીતની વાત હશે. So all these are the benefits of institutional arbitration. This professional administration relieves parties and arbitrators of administrative burdens, allowing them to focus on the substantive aspects of the dispute. It ensures that procedural deadlines are tracked, communications are properly documented, and the arbitration moves forward efficiently. For international arbitrations, where parties may be located across different time zones and jurisdictions, this administrative support becomes particularly valuable. Now, arbitrator appointment mechanism. Perhaps one of the most critical functions of arbitral institution is its role in the appointment of arbitrators. The selection of the right arbitrator can significantly impact the quality, efficiency, and outcome of arbitration proceedings. Institutions maintain panels of qualified arbitrators with diverse expertise across various fields of law, industry sectors, and geographical regions. When parties cannot agree on arbitrator appointments, the institution steps in to make appointments based on objective criteria. This function is crucial in preventing deadlock situations that could otherwise stall the arbitration process. The institution considers factors such as the arbitrator's expertise in the relevant field, availability, and capacity to handle the case within reasonable timelines. Independence and impartiality, language capabilities, and fee expectation relative to the dispute value. Institution invests considerable resources in vetting arbitrators before including them in their panels. They verify qualifications, experience, ethical standing, and availability. This due diligence provides parties with confidence that the appointed arbitrator meets high professional standards. Additionally, institutions often provide guidelines or default fee schedules, bringing transparency to the otherwise opaque question of arbitrator remuneration. Now, another important benefit is with regard to the provision of emergency arbitrator. Modern arbitral institutions recognize that parties may require urgent interim relief before a full arbitral tribunal is constituted. The emergency arbitrator mechanism addresses this need by allowing parties to seek immediate provisional measures through an expedited procedure. Under this mechanism, which is now featured in the rules of most of leading institutions, a party can apply for emergency relief immediately upon or even before filing a request for arbitration. The institution appoints an emergency arbitrator within a very short time frame, typically within a period of 7 days. This emergency arbitrator has the power to grant provisional measures such as prevention of assets, maintenance of status quo, or protection of evidence. The emergency arbitrator provision addresses a significant gap that previously existed in arbitration. When urgent relief was needed, parties had no choice but to approach the courts, potentially compromising the confidentiality and autonomy that attracted them to arbitration in the first place. The emergency arbitrator mechanism keeps the entire dispute resolution process within the arbitral framework, preserving the benefits of arbitration even in urgent situation. Perhaps the concept of emergency arbitrator made headlines within a Indian legal fraternity with the Supreme Court decision in the case of Amazon.com NV Investment Holding LLC versus Future Retail Limited, reported in 2021 SCC Online 557. Kunal, emergency arbitration वाला slide लगाओ. The legal framework governing institutional arbitration in India. Now, this is with regard to emergency arbitration, which I have narrated. These are the benefits and the one well-known case on this particular point, the case decided by the Honorable Supreme Court. Now, another aspect, another benefits, that is having examined the components of institutional arbitration, we must ask ourselves, what value does this framework deliver to parties choosing to arbitrate? The value proposition is multifaceted and addresses various concerns that parties have when entering into dispute resolution. There are certain benefits, advantages. Number one, first and foremost, is the certainty and predictability that institutional rules provide. Parties know in advance what procedure will govern their arbitration, what timelines to expect, and how costs will be calculated. This predictability is particularly valuable in international commercial arbitration, where parties from different legal traditions seek common ground. Second is the professional administration that ensures efficient case management. Time is money in commercial disputes, and delays can be costly. Time is money. As I've said, institutional support is managing timelines, organizing hearings, and facilitating the communications helps keep arbitration on the track. This efficiency translates into cost savings and faster resolution. Third benefit is the quality assurance that comes from a vetted arbitrator panels, scrutiny of awards, and adherence to international best practices. Parties can have confidence that their arbitration will be conducted professionally, that arbitrators will meet high standards of competence and ethics, and that the resulting award will be enforceable. Fourth advantage is the neutrality and credibility that established institutions bring. When parties from different jurisdictions or with unequal bargaining power arbitrate, an institutional framework provides a level playing field. The institution's reputation and established procedures create confidence that the process will be fair and impartial. The fifth is the convenience of having access to facilities, technology, and support services. Modern arbitration often requires sophisticated technological support for document management, virtual hearings, and simultaneous interpretation. Institutions invest in these capabilities, making them available to parties without additional burden. Now, the distinction between the ad hoc arbitration and institutional arbitration. Kunal, distinction wala slide laga. Now, what is the distinction, main distinction? You may see in the slide. I have prepared this particular slide. Second column is ad hoc arbitration. Last one is institutional arbitration. Now, with regard to administration, it is in ad hoc arbitration, it is managed entirely by the parties and the tribunal. There is no external body who can manage this. Whereas institutional arbitration is concerned, it is managed by permanent institutions like ICC, SIAC, LCIA, etc. Second is with regard to the rules of procedure. So far as ad hoc arbitration is concerned, parties must draft their own rules or adopt a set like UNCITRAL. Whereas institutional arbitration is concerned, the institution's pre-established rules automatically apply. Third aspect is with regard to the support staff. No administrative support is there in ad hoc arbitration. Parties handle all logistic and filings, whereas in institutional arbitrations, the dedicated case managers assist with the scheduling and record keeping. Now, most important is the appointment. So far as appointments are concerned, it requires party agreement or court intervention if deadlock occurs. Whereas in institutional arbitration, the institution appoints or replaces arbitrators, avoiding court delays. Next aspect is quality control. Now, no external review in the ad hoc arbitration. The award is final once the tribunal signs it. But so far as institutional arbitration is concerned, the institution scrutinizes the draft award to ensure it is enforceable. Now, timeline is also important. So far as ad hoc arbitration is concerned, timeline it is flexible but prone to indefinite delays. Whereas in institutional arbitration, it is highly structured with defined timelines and procedural certainty. Cost predictability. So far as first one is concerned, arbitrator fees are negotiated privately, can be unpredictable. Whereas institutional arbitration is concerned, fees are usually based on a fixed schedule or the sum in dispute. Now, emergency relief. Ad hoc arbitration is concerned, parties must specifically agree on and establish emergency procedures, often requiring urgent application to courts if no mechanism is predefined. And so far as institutional arbitration is concerned, pre-existing binding institutional rules automatically provide a framework for emergency arbitrator appointments and interim relief. So these are the broad distinction between the two, that is ad hoc and the institutional arbitration. Now, before I conclude, I must reiterate my profound gratitude to the Honorable Chief Justice of the Gujarat High Court for her vision in organizing this conference. To all the participant judges, lawyers, arbitrators, mediators, academics, and students, I thank you for your presence and engagement. Your participation demonstrates commitment to improving dispute resolution, to strengthening institutions, and to advancing the cause of justice. As we continue through these 2 days of deliberation, let us maintain open minds and constructive spirit. Let us critically examine current practices while remaining optimistic about possibilities. With these thoughts, I conclude this introductory reflection. Thank you for your kind attention. Now I will request my learned senior brother, Justice A.K. Sikri, to share his view on the subject. Thank you. Thank you so much. 。 . 。 。 。 . 。 . 。 . 。 . 。 . 。 . 。 。 . 。 。 . 。 。 . 。 。 . 。 。 . 。 。 . 。 。 . 。 。 . 。
. . 。 . 。 . 。 . 。 . 。 . 。 .
Thank you, Your Lordship, for a very informative and insightful speech. We now request Justice Sikri, former Judge, Supreme Court of India, and presently Judge, Singapore International Commercial Court, to take the session forward.
Thank you very much and good afternoon to all of you. My esteemed brother, Justice Pancholi, sitting on the dais, all the honorable judges of the High Court of Gujarat, present and past, our good friends, Mr. Janki Das and Mr. Shyam Devan, who have come from Bombay and Delhi respectively, many other judicial officers, judges from other courts, as it was said in the morning that there are judges from other courts as well. And not the least, but most important, the audience, the advocates who have come in large number, which shows your commitment to the arbitration in Gujarat and to ensure that Gujarat or this arbitration center, which is for which the foundation stone has been laid today, becomes not only a domestic hub for arbitration, but international hub as well. So in the beginning, at the outset, my very, very good wishes to all of you. And I always believe, and that I can say in the beginning itself, that such bringing about the institutions and making it success is always a joint venture where all stakeholders have to work with commitment and with honesty of purpose. And that is what I can witness here today. So my good wishes to all of you. The theme which we are given, me and Justice Pancholi, is about institutional versus ad hoc arbitration and a crossroad moment. In this context, Justice Pancholi has already in his very extensive and erudite address mentioned about the pros and cons, advantages and disadvantages of both the types of arbitrations, ad hoc arbitration as well as institutional arbitration. And so therefore, I would not be traversing into that field all over again and repeat that. I would, therefore, my endeavor in my address would be to see, to demonstrate, and to reflect, and then to discuss also, if time permits, I think time will permit, as to where Indian arbitration is and how we are at crossroad and what we can gain from the arbitrations, arbitral institutions which have come up in other countries and which have acquired worldwide recognition and popularity. I may say at the beginning that look, two comments. Number one, arbitration was conceived as one of the dispute resolving mechanism, which is alternate dispute, which has its attributes like flexibility, efficiency, autonomy, predictability, and affordability. There is a debate, that is my first comment, not only in India, but world over, whether arbitration has achieved these purposes or not. And everywhere, the reforms in arbitration are needed, and many arbitral institutions and many other jurisdictions also, which I have witnessed in last 6 or 7 years when I have been doing international arbitrations as well, that everybody is working towards that. That is one thing. So therefore, it's not that some of the aspects or some of the shortcomings which we find here are only typical to India or Indian context. They are elsewhere as well. Another thing which I wanted to say was that notwithstanding this, And there has been discussion in other countries also, maybe 20, 30 years ago, even in England, LCIA, which is one of the oldest arbitral institution. So there was a discussion that it may die soon, and it is not giving the results which it should give. But thanks to Michael Kerr in England, who could turn it around, and again the LCIA has got that kind of recognition. So therefore, if the that is what I am saying at the outset. Second message which I wanted to give from this, that even some of the obstacles or some of the difficulties which we are feeling or which we are facing in India, if we have wherewithal, if we have our commitment to that, we can also overcome and can be one of those international institutions and can be at par with that. Now, as I've said, Justice Pancholi has covered about the ad hoc and this institutional arbitration. And the message, if you have seen at the end of his address, comes to, even after being pros and cons, that ultimately it is the institutional arbitration which is going to help us in a long way and to take care of so many problems which the arbitral ecosystem which faces in India or even maybe elsewhere. So why these institutional arbitrations? What is the concept and what is the framework? If I may say so in very briefly, that they were conceived to bring uniformity in methodology to be adopted by the arbitrators in different arbitration matters. The purpose is to adopt a systematic approach in selecting the arbitrators from the panel prepared by the arbitral institution, frame the rules and procedure for conducting the arbitration in a structured, supervised, and system-driven manner. In contrast, ad hoc arbitration has case-to-case approach, which lacks uniformity, but the advantages of ad hoc arbitration could be that it is more familiar, more flexible, and more personality driven, where you choose your arbitrator going by that particular person and particular personality. So going by the various advantages of institutional arbitration, which it brings about and which Justice Pancholi has already alluded to, there have been a mushrooming of arbitration institutions all over the world. Some such institutions, particularly in international commercial arbitrations, which have gained global credibility, are LCIA, which I have mentioned, London Council of International Arbitration, SIEC, Singapore International Arbitration Center, ICC, Paris. In India also, we know many arbitration centers have come up, and the existence of some of them goes back to even more than 100 years. We have IMC in Mumbai, as everybody knows, this merchant chambers. For past time, there has been a trend to establish arbitration centers as adjunct to the high courts, like Delhi International Arbitration Center, Chandigarh, it was created, Chennai, it is created, Gujarat has also, now it is created. Even the government has come out with, in the form of legislation, and established India International Arbitration Center, IIAC. So the purpose is, and what we have been discussing, and the government is also saying, the judiciary is also saying, that we have to ensure that India also becomes a hub for international arbitrations. Insofar as domestic arbitrations are concerned, apart from some of the anomalies which with our domestic arbitrations suffer, but then fact remains that domestic arbitrations have mushroomed. Fact remains that whether it is ad hoc or more particularly arbitral institutions, which have been able to cater to the domestic demand. And we have like FICCI, ICA Arbitration Center, which was, I think, is pre-independence, which was established. And they do hundreds and thousands of cases every year, which is impossible, and such a kind of figure is mind-boggling, which no international arbitration center, all those bigs which I have told you, have gone to that extent. That is not a problem. That problem comes when whether we are able to create that kind of ecosystem in India, that we should be in a position to attract international arbitration. That has not happened so far. But what is before that, and in order to come to that and discuss about the crossroad, I would say for an arbitral institution to become an important and meaningful institution, a successful institution, what is required? If I may say so briefly, that the key factors which make an institutional and user-friendly institution are: number one, robust legal framework. So that legal framework, that is legal infrastructure, coupled with, of course, our physical infrastructure as well, which we were discussing in the inaugural session. The legal infrastructure should be such which supports arbitration, and we have to have the rules which are international compliant. And going by UNCITRAL model law on international commercial arbitration, like in India, we have enacted the Arbitration Act. They have been amended from time to time. The statutory framework is there, but when it comes to arbitral institution, they have to have their own rules. They can always look into the various ethos, various principles which are enshrined there, and can incorporate in their own rules, to which I will elaborate as I progress. Second is efficient and neutral process. The process has not to be only efficient, but it has to be neutral as well. When we talk of efficient process, we talk of it has to be cost effective. It has to be speedy as well, with a strong focus on procedural fairness and transparency, which is very, very much required. And many, I may tell you here again, many international institutions suffer from this quality. They lack this quality. Third attribute, or the key factor, which I would say is the global recognition and enforcement. Whether the awards which are given, particularly international awards, and under the aegis of that particular arbitral institutions, what is the respect they carry when it comes to enforcement? If it is the seat of that award of that particular country, naturally the challenge would be in that country. If it is India seated and the award is given, it may be an international arbitration, but then it will be, the challenge to that will have to be in India. But when it comes to enforcement, because suppose this award is given against a company which is German company, people will go for enforcement there. Likewise, if it is Singapore seated arbitration and again it has award is resulted against India, they will come to India for enforcement. But therefore, the award given by a particular, under the aegis of a particular institution, how much respect it carries, and the global recognition and enforcement of that award becomes very, very important. Here, we may not have much of a problem because of New York Convention, where, more than also, I think almost 170, 180 countries have already become signatories to this. India is among them. So therefore, that may not be much of a problem. But how these awards, when they go to other country, are respected, that may be, because I tell you, as a judge, I can say, and judges who are sitting here, Justice Pancholi, whenever an award comes before us, when I was judge for consideration, of course, we will go by law, but first thing we'll see that who is the arbitrator who has given that award, and what is his, what is the respect which he enjoys, what is the knowledge which he enjoys, and whether that domain knowledge, etc., that is there. That is always at the back of mind. That may not influence the decision-making process, but may contribute to some extent, if I may say so, very, very frankly and fairly. Other key factor would be innovative procedures. So arbitral institutions need to introduce innovative procedure like streamlined procedure, expedited procedure, coordinated proceeding to enhance efficiency and reduce cost. There are, in many of these international institutions which I have referred to, you will find that there are rules containing that if the case can be expedited and fast-tracked, the stakes are less, so it can be decided then within even 2 or 3 months. So those kind of procedures are there. And next is strong institutional support, to which Justice Pancholi also referred to, that you need a multinational secretariat and experienced staff for providing excellent case management services, supporting parties throughout the arbitration process. I'll come to that when I come to in the context of India. Then seventh attribute which I find is that commitment to transparency and accountability. So it is absolutely essential that rules and procedure prioritize transparency, fairness, and accountability, fostering trust among users. And I have seen there are rules like, no doubt we have that provision under the our Indian Arbitration and Conciliation Act. If suppose there is a challenge to the appointment of some arbitrator, nominee arbitrator or otherwise on account of bias or other things, although rule of competence applies, and in the first instance it has to be taken before the arbitral tribunal, and if arbitral tribunal decides against that, the judgments are very clear, rightly so, that it can now be only at the end when Section 34 petition is filed, at that time it can be challenged. But many arbitral institutions within themselves have this framework. When such a challenge comes, what are the parameters on which it has to be applicable? Again, I would say we have Schedule 5 and 6, Schedule 7, which talk about the impartiality and take care of the conflict of interest, etc. But notwithstanding that, the arbitral institution can have its own rules and its own mechanism. Like ICC has the rules whenever there is such a challenge, it is first not the arbitral tribunal, but the ICC secretariat which decides. There's one case going on, very interesting case. Let us see, it has landed up in Supreme Court, so I can't say much about that. I am a part of that arbitral tribunal where the challenge is laid to the independence of another arbitrator. Very interesting situations that happened. The same challenge is rejected by Singapore court, but here Delhi High Court has accepted that, and the matter is pending. I think Mr. Shyam Diwan is doing that case because he's smiling. I don't have any idea about it. But then the rules, if they are of the arbitral tribunal, those rules are there in the arbitral institution. They help a lot, which I have seen from my own experience. So what are the, these are some of the factors. And when I come to, let me now in brief state about the what are the factors which led to the success of foreign arbitral institutions. Some of the key factors which I have mentioned, they are with them, they are there. But to say so very briefly, first is, as I said, professional management of institutions here. I have seen myself doing, having done some cases under the aegis of LCIA, ICC, SIAC, etc. They have their very trained managers who understand arbitration law. Now, these are the persons who are administering secretarial staff, but they have very, very good knowledge of the entire arbitration law as well. Not that they are working only as a clerk who are totally oblivious about the legal position insofar as arbitration law and how it should proceed and what are the various judgments, important judgments which are given in international area or by the domestic courts, etc. They have very good knowledge about that. They understand arbitration law. They understand procedure. They understand commercial expectations. And that is why I have seen that whenever a particular person is appointed, right from the stage when you are nominated and your appointment is affirmed or approved by the arbitral institution, the way they act, and at every stage, the way they, monitor in a true professional way, that is really remarkable, which in India, and I will call upon your arbitration center, which is going to be set up, must keep that in mind. And the process of the filing of cases is structured, simple. At the time when I mean, from very beginning, the people, not only the arbitrators who are to be appointed, they are apprised of various rules which touch upon the impartiality and conflict of interest, etc., but about the procedure as well. Likewise, the parties who go to that particular institution are told about, are made aware about those rules, which will become very, very important. And the way the arbitrations are conducted, and one thing which I may say so later, but what I am just at this stage mentioning is that one unfortunate thing which I have seen in domestic arbitrations, even when they are institutional arbitration, they go like suits in the court. And what happens, like when the pleadings are filed, timelines are fixed, but then most of the time not adhered to. There would be some request for extension of time. Even when we are given the dates, we have to keep on cancelling those dates. And then the evidence will start. So today, 3 days are fixed. Then after 3 days, after 2 months again fixed, after 2 months again fixed, and it may go on for 1 year, 1.5 years, whatever. Of course, thanks to Section 29A, where timelines are to be, matched by the arbitral tribunal. So it has made the arbitral cases, even ad hoc or institutional domestic arbitration, much more, structured and effective. But apart from when it comes to arguments also, then again, dates to dates to dates to dates. In international arbitration, in the very first hearing, CMC, which again Justice Pancholi mentioned about that case management conference, with the consent of the parties, timetable from day one when the pleadings will be filed till the date of final arguments is fixed. And then it is not changed, because it is fixed with the consent of the parties, and evidence followed by argument in one tranche. Whether it is 5 days, 7 days, 8 days, case will go on, and from evidence to argument, it will finish. And thereafter, it will be only the award which is to be given. So this is one very, very important thing which we have to, professional thing which we have to learn. And arbitral institutions are the only institutions which can really, not only encourage, which can implement and which can thrust upon the arbitrators who are appointed that you have to go, which can tell the parties also, if there are rules to that effect, they can say that these are the rules, you have to go by those rules. Second thing I would say about the panel of arbitrators, the arbitrators which are chosen, they are totally based on merit, integrity, experience, and most importantly, what is happening now for last, I'm seeing 1 decade or so, diversity. Many, actually 3 or 4 cases of mine I know where the institution had to appoint I was nominated, and institution had to appoint the presiding arbitrator was a female. In most of the cases, they are going by diversity they want, and diversity here doesn't mean only based on sex, male or female. It is, countries wise, region wise, ethnic diversity, etc. They want to bring all this. And in international arbitration, that breeds confidence, because we know and we have suffered. And that is happening even today in investment arbitrations in the world, that it is the white dominated, Western dominated world. It is in North, global North, which is doing that. And we don't have that kind of confidence. And that is actually, there have been cases. And that is one reason, let me tell you, Singapore has been able to, steal a mileage by telling the Asian community, look, don't go towards West. Here we are. We are more cost effective and we are more friendly. That is the kind of confidence we can also generate, particularly when we talk of international arbitration. Proceeding slowly and initially, first step can be not necessarily go all over the world, but go to that Southeast Asia, then West Asia, then rest of the Asia, then global South. of which India is becoming a leader in political sense. Then why not here also? So those are some of the things which we can do, but then the panel of arbitrators has to be chosen like that. Then marketing. Let me tell you, of course, as far as our judicial system is concerned, it is already overburdened. And we don't want judges say that, look, we don't invite cases. The cases are thrown at our doors, and therefore we have to decide. But when it comes to international, it comes to arbitral institution, we want to attract work, particularly international, work, arbitration work, and there's a lot of competition in that. I give you one example. It was in 2006 or 7. I was judge in Delhi High Court. We had there were some lawyers, arbitration bar of Delhi, and a few judges. We were led by Justice Lahoti at that time in the Supreme Court, and we had gone to Singapore SIAC at their invitation. And we were shown their setup, etc. And thereafter there was 2 hours seminar. For 1 hour, first hour, the Indian speaker spoke, Justice Lahoti spoke, I spoke, and there was one president of our association who had gone there. We spoke. We were talking about Indian arbitration, what are the difficulties we are facing, and if you remember at that time, the 2 cases which or judgments of the Supreme Court which stared at us, Bhartiya International and ONGC saw pipes. So we were there just defending, justifying, and all that. After us, tea break, and then our counterparts had to speak. So there was one Supreme Court judge, sitting Supreme Court judge. There was Attorney General, and there was SIAC CEO. They did not say much about what is the law, how it is. They said, we are most friendly, arbitration friendly, come to us, come to us. That was the message all 3 gave. The judge said, look, we are very friendly. Our judgments are such, if you see, and they are in aid of arbitration, we don't unnecessarily interfere. The Attorney General said that the government here supports arbitration in full strength. So the ecosystem is really good. And likewise, SIAC said that look our management of this, and look our rules, look our this is the best place you come to. What we do in contrast, whenever there are even international seminars or other things, etc., we keep criticizing ourselves. We should have positive attitude, and we should highlight not that India has not achieved much, but we should try to highlight that. We should try to project that we are also very good, come here and we will deliver. Of course, there are challenges for that, and we have to face that, but then we should remove that. What I'm saying, that negativity should not be our approach. And I'm saying about the marketing in that sense. About professional management of cases, etc., I have said. What is about rules, I tell you, if you see the rules of these arbitral institutions there has been always, very periodically amendment and changes. And they keep on introducing new concepts. Emergency arbitration, which Professor Justice Pancholi referred to, is in their rules. Then he mentioned about this judgment in Amazon versus that case, Amazon case. What in our India, whether emergency arbitral award is award itself or not, it's a subject matter of challenge. Law Commission had given in its report that the definition of award should be amended to include that, which was for whatever reason not done by the court. So therefore, in some of the institutions, I have seen MCI also has the provision for emergency arbitration, and but arbitral award which is given, what would be the sanctity of that? There were judgments at that time, one of Delhi High Court, of Bombay High Court, that if emergency award is there by other court, it is given, it comes here, you have to file an application under Section 9 again to have that order. And only then it will implement it. But thanks to Amazon judgment and the far-sightedness of Justice Rohinton Nariman, who gave that judgment, and he judicially recognized emergency arbitrator awards as awards enforceable under that act. But then what I'm trying to emphasize here is that the very, very innovative things, like now there are provisions about third-party funding. So there should be some provision because there is debate about third-party funding in India. Very fierce debate is going on, whether it is ethical, unethical, etc. But then there should be a regulatory mechanism. If it is, there's no law passed by the parliament, but then it can be in institutional rules also about that third-party funding, and then it can take care of many things. Another thing which I would say, and there is a, going to be a session on that last session, which I say, see, in your, and that has happened in many arbitral institutions, introduce the approach, composite approach of ARB-MED-ARB or MED-ARB-MED. The rules should cater to that. And because that would encourage, I think both are complementary to each other. That will not only encourage the arbitration, but will encourage the mediation as well. I would say at the end that, look, we have been able to, insofar as our management services are concerned, our IIMs, our IITs have done wonderfully well. And the Silicon Valley, which is today in America, is all dominated by Indians. But we have established Silicon Valleys in India as well. We have the example of Bangalore, we have the example of Hyderabad, now we have the example of Gift City. So why not we are able to create arbitral institution also in that sense, if we can do it in other, in other fields. We have created health tourism. When many people come here, then for their health, because of the medical services are cheap, and then they come here and then they go for tourism also. This is health tourism. I remember the law minister of Singapore saying, like, India has created health tourism, we have created legal tourism. So why not there should be legal tourism in India? So let us try to create that. And so it has to be said that we have to have that kind of arbitration culture where advocates and arbitrators, we have to go together. It should not be only a part-time work for the arbitrators, the advocates. It has to be given full-time, and the manner in which these are conducted, not like civil suits here. And some of the attributes which I have told about the international arbitration, I think we have to imbibe good practices, of course, with indigenous flavor we need to provide here. And so thank you very much for giving me this. And I feel the way forward is that more professional approach and training at the end only, I am saying, training even of the arbitrators. There should be some courses. I tell you very frankly, being a judge, I can criticize myself. Many judges after retirement, they think that the arbitral work is same as the judge judge of who's deciding court cases. There's a lot of difference, if I tell you, I've seen in last 6-7 years. But many of our judges don't agree to that. They said, no, I have been judge for 20 years. I have learned a lot. I don't have to learn at all. But that there is a lot to learn. Even the way the awards are written, international awards are written, I have seen, they are totally different than the way we write the judgments. I only tell you one thing. In one case, there was one, but I can't name the name also, and can't tell the this award came, and I only changed some of the language. And the judge was Supreme Court judge, much senior to me. He was furious at me. Said, don't you think how to write? Don't you think I don't know how to write? I've been writing judgments for 20-25 years. You are teaching me how to write it. I said, sir, only thing is I'm just changing it to the way the arbitral awards are written. But he said, sorry, I'm not going to accept. Anyway, so therefore, what I'm trying to say is that we should be open, even arbitrators like advocates should be open to learning. There are various different kinds of techniques when it comes to arbitration. And so your institution should have in a regular manner events lectures of persons, international personalities, conferences, symposia, seminars, and training programs also. Thank you very much.
We are thankful to Justice Sikri for his erudite speech and the suggestions that he has given for a robust institutional arbitration will surely show a path to the Gujarat High Court Arbitration Center. More particularly, his concepts that he has told us regarding efficient and neutral processes, global recognition of awards, the diversity in the panel of arbitrators is surely going to help us when we come up with our arbitration center. This is the right moment for us to open the floor for discussion. I invite Mr. Kunal Vyas and Mr. Arjun Joshi, learned advocates, to come up on the stage and engage with the speakers, ask questions and seek clarifications so that today's learning becomes truly interactive and grounded in real practice.
Sir, we are conscious of the fact that we are running short of time, but we have taken some pertinent questions from the audience. The first question is for Melod Justice Pancholi. Sir, you spoke about emergency arbitration. After an emergency arbitrator decides the interim application, does he or she become functus officio and disqualified from being appointed as a member of the main arbitral tribunal?
કુણાલ વધારે સમય ના લેશો કારણ કે બધાના મોઢા પરથી એવું લાગે છે કે બધા થાક્યા છે અને ભૂખ લાગી છે બધા હસી પડ્યા now so far as this particular question is concerned, see, as per my understanding, once the emergency arbitrator passes an award, he becomes functus officio. Now therefore he cannot be appointed as an arbitral tribunal, because once he has passed an interim order in emergency while acting as an emergency arbitrator, he cannot act further in that particular dispute. That is my answer.
I may only add. Another most important reason is he cannot be appointed because they ultimately that is subject to, because when the arbitral tribunal is constituted, they may vary, they may modify, they may set aside that order. So how he can sit and review its own order.
Thank you, sir. Thank you.
So from your address, two reasons which you reference as challenges are an absence of a perception of neutrality and impartiality and cost sensitivity. How would you suggest domestic institutions should prioritize? Whether it should be cost undercutting foreign institutions' pricing without undermining quality, or should they establish credibility first? Or do you think both can be done simultaneously?
I think simple answer is both have to be done simultaneously because both are very, very important key factors. And of course, as I said, the very arbitration which was conceived and conceptualized and was this, that it is efficient, that court delays, it doesn't breed those kind of delays. That is perception, I am saying. And or that was a reason also. Because in courts, we are bound by the procedure. That is why we say there's a specific provision in the Arbitration Act itself that the arbitral tribunals are not bound by the code of civil procedure or rules of evidence, etc. So the purpose was this cost and speedy. Other is cost effective. That I mean, if I may say so, tariq pe tariq in judicial system. So therefore, yes, Mr. Sham Diwan appears. If the date is given, he will still charge his fee. So therefore, when I remember, I tell you very interestingly, way back, I had just joined the profession. I think it is 79 or 80. And I was really surprised to see the comments of that judge. One Justice H.L. Anand, I don't know, even Mr. Shyam Dewan may not be knowing. He was in Delhi High Court, and most of his he was in those days in 70s 80s was working in some firm of big firm of lawyers, etc. There were very few in India at that time, and he was saying one day in the court that look, 99% lawyers come here in the court for 1% work, and 1% lawyers are enjoying and they are earning a lot in arbitration. I was at that time, naturally, it was such a, I mean, statement which we were very surprised, but ultimately I found he was right. Reason was that look, you come to the court, you are waiting for your turn may come, may not come, or it may come after 2 hours, 3 hours. But in the arbitration, it is fixed at 10 o'clock, it will start at 10 o'clock. Arbitrator doesn't have 20 cases on that day, it has only one case. So therefore, that is one reason that people choose arbitration, and then party autonomy and other things, etc. And so both cost as well as predictability and the authenticity of the arbitration process are important.
Thank you, sir. And I believe these are also experiences that you may have had while you are a judge of the Singapore International Commercial Court. But sir, what are the lesser known procedural or structural features beyond the commonly discussed aspects which you believe require improvement in such arbitration ecosystems, which we
I
can
think
adopt?
I have reflected on that. If you want, I can little bit dilate on this. Is about the case management. And I told you about med approach also. I will allude to that also to some extent. First is, it is what happens. It's not when the arbitration in the beginning itself, the entire arbitration, how it should proceed. And when the parties have, although it's the first date and where, but by that date in the notice of arbitration, which one party had given and the other party had given reply, one can clearly fathom from that what is the case of the parties about. Correct. So on that basis, that the entire and the parties, the first procedural order which is passed and which is settled, of course, with the consent of the parties. Wherever the parties don't agree, then the arbitral tribunal chips in and would give its own verdict that, okay, it should be done like this. But then, since party autonomy is there, most of these things parties do agree, 80%, 90%. But then, as I said, the timelines from that within how much time the statement of claim would be filed, which is plain, statement of defense would be filed, like your written statement, etc. When the evidence would be filed, when the application for this production of documents, etc., interrogatories, and even the arbitrator, when they would give their decision within how much time, and when the affidavits will be filed, affidavits of experts would be filed, and on the very first day, the parties know how much time they will take for, it is called evidential hearing, whether it will go on for 5 days, 6 days, 7 days total. And that is fixed in the beginning. In India, what I have found is that on the first day we come, the lawyer says that I have not even studied the paper. I don't know how much time I'll take in filing the statement of claim. And same way, the other lawyers also. When we say, okay, you take 8 weeks of whatever time they take for evidence, they say, sorry, first, after that, let there be a date, and then we'll see who is going to be the evidence. And all those affidavits in international arbitration filed along with the pleadings or immediately after the pleadings. And there they will take time. At that time, they will decide how many witnesses we have to examine. When we ask the parties, suppose claimant has filed the 5 affidavits, 5 witnesses, how much time the other side will take? They say, oh, let me read only then when I prepare the cross-examination, I'll see how much time it will take. The other problem is that the timeline is in most of the cases not adhered to. If they say I will take 3 days, after 3 days we find even first witness is not cross-examined. And they want further time, further time, further time. That is why it happens. And cancellation of dates is very, very common here for one reason or the other. And so therefore, I mean, there can be a detailed discussion on that. But this kind of professionalism has to come. I tell you, and that is for our judges also, particularly here. I think you don't have original side in Gujarat High Court, but wherever original side and judges, in my in Singapore arbitration, in my Singapore International Commercial Court, which I have seen, there also CMC is there, case management conference. And it is very clearly when the case is coming up and the registry and the registrar, etc., are so well trained and they take care of everything. Yes, for on small things, on by mails only will they will say this is what is said for small things, how we have to, what orders could be passed, no hearing, nothing, and all those things are taken care of at the at the level of registry only. And when the case comes for the arguments, evidence or arguments, the registrar holds that conference, will talk to us, and they will tell how much time they will take. Not a single minute more is taken actually thereafter. And likewise arguments. Because it is another reason is their costs are prohibitive. We ultimately say, okay, let the parties bear their own cost. That is not the concept there. If the losing party has to pay the full cost of the other side. So therefore, if I have to argue the matter and I know that it should be argued in 2 hours, I will not ask for 4 hours. My cost will escalate if I ultimately lose. So therefore, they adhere to that. This is one thing which we should.
Thank you, sir. Justice Pancholi, just one more question. Sir, again on the issue of emergency arbitrators, once a party approaches an emergency arbitrator and an order is passed, can a party still approach a Section 9 court?
According to me, once the emergency arbitrator has passed an interim measure award or order, then there is no necessity to go before the court under Section 9 of the Act. But let us assume the reverse situation, converse situation, where the emergency arbitrator had not granted any relief. For the same purpose, for the same relief, can a party approach under Section 9 before the concerned court? My answer would be no. Application or proceedings are maintainable. Application is maintainable. But ordinarily, court will not entertain such type of application once the emergency arbitrator has refused to grant any relief in favor of that particular party. If I'm
You're perfectly right, and I only add one thing. That is why, if it is treated as award, then you can't file an application. You can challenge that award, and so then that process is available to you.
It is like a constructive right judicator.
Thank you. Thank you so much, sir.
Justice Sikri, one last question for you. Sir, you had spoken about access to justice also. To what extent can institutional arbitration reconfigure power imbalances between arbitrating parties and emerge as a more uniform and neutral dispute resolution mechanism?
You see, when I talk of access to justice and fairness in the procedure, etc., it includes fee as well. One thing I have seen in Singapore International Arbitration Center, normally what happens in arbitral institutions, when you invoke the arbitration and any say suppose Gujarat High Court Arbitration Center, so they have their scale of fee. They'll say, okay, you have filed a claim of say 200 crores of rupees. As per this, they will calculate the fee and they will ask you to pay that, deposit that amount. Plus, your share, half share can be of the other side. Likewise, administrative charges, etc. Many times, the parties may not be in a position to give that in one go or in the beginning. So when we talk of access to justice, it becomes access to justice in arbitration also becomes very important. And in Singapore, they have the system or rules are that stage wise, when the case progresses, you can deposit the fee. So that is one thing which can be, taken care of in the rules which are going to be, or which have been formulated, or you can always amend that rules. So that is one aspect which has to be kept in mind. Other is, as I've said, there's another thing which I've seen in many arbitral institutions, that they, while I mean managing the cases, they also follow up what the arbitrators are doing when the hearings etc are taking place. And every time there's always one person who is assigned to that case, the deputy counsel or whosoever, whatever is the nomenclature. So they see the manner in which, even the arbitrator is under scrutiny, and whether arbitrators or the arbitral tribunal has been able to hasten the process, and not that unnecessarily delays taking place in passing interim orders also, like under ICC arbitration. After the hearing is complete, within 3 months you have to give the award. So there's a time lag. If not that, after 3 months, there's a rule that your fee can be reduced of the arbitral tribunal. No, and that may become ultimately, it may be a negative factor that in future it may affect marking cases to you. So therefore, these are some of the things which can be, taken care of by the arbitral tribunal in bringing out more transparency also, and a more efficient system as well.
Thank you. Thank you for an engaging discussion, sir. This marks the end of our session.
Thank you so much.
Thank you, Your Lordships, for this engaging discussion. Let us now take a moment to thank our speakers. May we now request Honorable Mr. Justice Sanjay Gowda, Judge, High Court of Gujarat, to felicitate Honorable Mr. Justice Vipul M. Pancholi, Judge, Supreme Court of India. May we now request Honorable Mr. Justice Nirzar Desai, Judge, High Court of Gujarat, to felicitate Honorable Mr. Justice A.K. Sikri, former Judge, Supreme Court of India, and currently Judge, Singapore International Commercial Court. With that, we conclude the first session. Let us now break for lunch and reconvene after an hour. We request the honorable dignitaries to head for lunch to the left side of the lawns, and we request the members of the invite them on stage. Welcome back. I hope everyone had a good break and are ready for the next session. The topic for the second session pertains to the role of advocates and arbitrators in making the alternate dispute resolution process more ethical, effective, and efficient. May we invite on the stage the speakers for the session, Mr. Janak Dwarkadas, Senior Advocate, and Mr. Shyam Diwan, Senior Advocate. It is a privilege to introduce the speakers for the second session. Mr. Janak Dwarkadas is a senior advocate and one of the doyens of the Bombay Bar and a leading figure in commercial litigation and arbitration in India. Mr. Dwarkadas has practiced on the original side of the Bombay High Court since 1977 and was later designated as a senior advocate in 1997. He is widely recognized for his sharp legal acumen and courtcraft in complex commercial and arbitration disputes, regularly appearing in major domestic and international arbitration and related court proceedings. He has been involved in several high profile and sophisticated arbitration litigations, including representing Max Healthcare before the Bombay High Court in a dispute concerning the proposed sale of care hospitals, where significant issues relating to interim relief and arbitral authority were closely examined. Beyond advocacy, he has had an active role for arbitration reforms, consistently advocating for institutionalized arbitration and specialized tribunals with domain expertise to enhance efficiency and certainty in dispute resolution. He has written and spoken extensively on arbitration policy and practice and continues to shape the arbitration discourse through publications, panels, ADR forums. Practical, persuasive, and deeply experienced, Mr. Dwarkadas brings together courtroom vigor and a reformer's perspective, a combination that makes his insight especially valuable for today's arbitration community.
Our second speaker for today is Mr. Shyam Devan, senior advocate and one of the India's most respected constitutional and commercial law practitioners before the Supreme Court of India. Widely regarded for his intellectual clarity and persuasive advocacy, Mr. Devan has appeared in several landmark matters across constitutional, environmental, and commercial law, and has been deeply engaged in significant arbitration-related questions before the Honorable Supreme Court, including the 7-judge reference on the validity of unstamped arbitration agreements, a case that has had far-reaching implications for arbitral enforceability in India. A consistent and principled voice in favor of arbitration reform, Mr. Devan has repeatedly emphasized that when parties choose arbitration, courts must respect that choice and that arbitral awards should be interfered with only in the rarest of rare cases. He's also advocated for institutional arbitration, development of specialized arbitration bar, and higher procedural standards. He's the co-author of Environmental Law and Policy in India, Cases and Materials, 3rd edition, Oxford 2022, and has authored chapters on public interest litigation in the Oxford Handbook of India Constitution. In 2021, he received the International Privacy Champion Award from the Electronic Privacy Information Center for his role in a set of privacy protection case. Thoughtful, principled, and reform-oriented, Mr. Devan brings both constitutional depth and commercial realism to the evolving arbitration landscape.
May I now request Mr. Dwarkadas to take the session forward.
Good afternoon, everyone. Thank you, first of all, to the Chief Justice of the Gujarat High Court and other judges of the Gujarat High Court and the organizing committee for inviting Shyam and me here to speak to you all today. It's a pleasure and privilege to be here. And I hope this session encourages the improvement in standards of advocacy as well as in the arbitration machinery itself becoming efficient, ethical, and taking the way forward. With that little introduction, let me talk to you now about the subject we are here for. India is on the path to become a $5 trillion US economy. If we are going to get there, or if we want to get there, I don't think there can be any doubt about the fact that with more business, more investment, and more commercial activity, we certainly need a transparent and efficient system by which disputes which are bound to arise, there cannot be a
in that sense, commerce without disputes. Machinery which is available to resolve those disputes. Now, we have tried our hand in 2015 to enact what is called the Commercial Courts Act. At least I can only speak from the experience we have in Bombay. I am not very sure because I don't travel now for matters outside of Bombay, but I'm not very sure whether the practice in Bombay is not what we find in the rest of the country. In Bombay, what we have is not commercial courts in the strict sense. What we have is a commercial division within the existing court system. What does that mean? What that means is that the same set of judges who already are tackling a huge amount of backlog and who have various other assignments on their board are, in that sense, their burden is enhanced or increased by adding to their burden a commercial division. Now, my sympathies have always been for the judges of our country, whichever court they may belong to. They are woefully inadequate in number compared to the population. I have said this on numerous occasions, on numerous platforms, that if you make one horse do the work of 12 horses, the horse will die. But judges are not doing the work of 12 horses, they are doing the work of 100 horses. You must have read today, a judge in the Allahabad High Court said, out of exasperation, I am hungry, I am exhausted, my mind is not able to function, and I am rising. It was at 7 p.m. on that day. I mean, at least he spoke what probably many of you judges who are here probably are experiencing, and we as lawyers have experienced. I mean, I can tell you about one particular judge in Bombay, Justice Kathawala. I mean, hats off to him for having the ability and the patience to sit till 2 in the morning and whatever, midnight and 3 in the morning or whatever. And of course, in a lighter vein, we often used to joke how he could do it without having to visit the loo, but that's a separate story altogether. We are not going to go there. But he tried to put in a Herculean effort, I mean, if I may put it that way, to do the work of 12 horses by himself. I mean, it is impossible. The backlog is just too huge. And some matters do require more time than others. And you can't, therefore, fight the system, whatever it is. So this Commercial Courts Act of 2015 has not really yielded the result. It's because we may not have the expertise that commercial courts or judges of the commercial court are required to have. It may be because the workload already is so heavy that they cannot handle anymore. It may be because we have become, and I remember Shyam's fathers, I'm quoting Anil Bhai's words, many years ago, I can't even remember, maybe it was 25 years ago or even more. He used to tell juniors like me at that time that don't forget, India as a country has become a court of interim applications. Interim, which means one step away even from interim, forget final hearing. Now, in the commercial court in Bombay, that's exactly the plight of the litigant. Judges now are forced. I'm not, again, please don't misunderstand. This is no black mark against the judges. They are, in fact, doing a phenomenal job. But by reason of the lack of time and the fact that every single day they have a docket of 100 cases, a minimum, they just cannot handle the load. So they look to give what are called ad interim reliefs to tide over that particular urgency that may be there. One of the most embarrassing questions I have been asked, not once but several times, from many a foreign litigant who sometimes out of exasperation will send an envoy to meet us in our chambers, and he will come and ask a very, what to us might be a very stupid question, but to him is a very perplexing one. What do you mean by change of assignment? And you have to start virtually from scratch and say, well, we have a practice where we try and give as much experience to our judges to do not just one particular, there's no super specialization in our courts. So, he'll be doing 8 weeks, he'll do commercial, next 8 weeks, he'll do criminal, the other 8 weeks, he may do tax, and so on and so forth. So that as and when he does become fortunate enough to go to the Supreme Court, where again there is no super specialization, he should be able to handle whatever comes their way. So, but for a foreign litigant, it is whatever however we try to simplify and justify and explain, it is beyond their ken. According to them, a case is a case is a case. Once a judge takes it up, unless he just passes away or somebody passes away, he is duty bound to finish it and see it to its end. So this system which we are following is, in a sense, more out of desperation, more out of exasperation, and more out of just having to deal with the sheer backlog we have. Now, why do I mention this, and why is it that I'm emphasizing this right at the outset? The reason is this: we want to become a 5 trillion economy. And I hope and we pray that we do become a 5 trillion economy and people do look eastwards for a change. But if we are not able to provide the machinery to resolve commercial disputes, I'm afraid we are not going to be very successful in attracting that amount of capital. And I'll tell you why. A simple truth I'll speak. When you talk of ease of doing business, what does it mean? I mean, we use the expression so freely as if it's just a cliched expression. Business is an enterprise, by definition, is an enterprise undertaken for profit. Now, the word profit is very, very important because no business, no service, no business can operate on the principle that it will give that entrepreneur bumper profits. There are a few who may have been able to bypass the principle and be an exception, but by and large, you can say profits would be in the range of 10 to 15%. You take any multinational, take any of the big corporates, at the end of the day, that's where you'll probably average out. Maybe in the beginning you may go in a loss, or beginning you may go up. I'm not talking about the startup bubble. So if you're talking of a 10 or 15% margin of profit, and if your average inflationary rate, I'm not talking of the published figures, is about 6 to 8%, can you imagine a businessman or an entrepreneur who's working for that 10 or 15% profit margin? I mean, the only example I can give you is what happened a few weeks ago on the Bombay-Pune highway. A tanker with gasoline overturned and the traffic was halted for 32 hours. So for a businessman who has a dispute with a person who owes him money, and right smack in the middle of his enterprise, where he would have expected to earn a 15% return, the other side raises a frivolous dispute, it's as good as being stuck on a 3-hour journey to Pune for 32 hours where your car is immobile. That is the closest example I can give you of what happens when your systems are not geared to providing early resolution to commercial disputes. There is no question of any entrepreneur making a profit when his money is locked up for 20 to 30 years in a commercial dispute. he might as well write it off and take a write off in income tax because it is of no value. Inflation would have made it zero or whatever he gets. And don't forget the fact that we don't award costs at actual in courts of law at least. So again, coming back to the beginning, Commercial Courts Act of 2015. Today, simple example, Section 12A was introduced into the Commercial Courts Act. The idea was that you must have mediation as a compulsory means before you can go into a commercial dispute. The idea was that by mediation, if the dispute could be resolved in 3 months, why make the plaintiff go through a commercial litigation? You know what has happened in reality? When we have become weaponized, as one of the judges of the Bombay High Court put it, weaponized, where the defendant will say, you've not taken 12-day leave, there is no case of urgency, it is all a bogus thing, the pleading is bogus, takes out an application, application gets into the queue, and there you have it. The 3 months are gone only in reply, rejoinder, date for hearing, etc., etc. Commercial dispute goes on the side, ad interim goes on the side, 12 days argued, carried in appeal, then to the Supreme Court. So for many reasons, I don't want to now enumerate, but for many reasons, our act does not work. And if that act has not worked, what are you left with? The normal system of dispute resolution is clogged. It is already has not one but several tankers lying on the expressway which will not allow any free flow of traffic. So you can't go to the normal courts, you can't go to the commercial courts. Then the only alternative is arbitration as an alternative means. Now we have the 1940 Act. The 1940 Act, as many of us have read and reread, and this has been probably cited times out of number, Justice D.A. Desai had lamented in 1981, if I'm not mistaken, in the Guru Nanak Foundation case about the 1940 Act. And I'm afraid we can use that language even for the 1996 Act. However, the way in which the proceedings under the Act are conducted, I'm quoting, and without an exception challenged in courts, has made lawyers laugh and legal philosophers weep. Unquote. I think 1940 was replaced by 1996. Now 1996 is based, mind you, on the Sutral model, which has been adopted by more than 140 countries. It seems to be working right. In other jurisdictions, it seems to be working right. In India, I think we are at the stage where Justice D.A. Desai was in 1981 when he spoke about the 1940 Act. Again, what is the reason? And I'm not trying to again be critical of the system, etc. But if one has to just identify, again, without pointing fingers, one is to identify what is it that has gone wrong, then we have to look inwards. We have to look at ourselves. Why do we have to look at ourselves? Because when B.R. Ambedkar was asked about the Constitution at the time that it was being framed, he was asked the question, how good do you think the Constitution is? And I quote what he said, however good the Constitution may be, it is sure to turn out bad because those who are called to work it happen to be a bad lot. However bad a Constitution may be, it may turn out a good one if those who are called to work it happen to be a good lot. Unquote. Now again, this is not an exercise to point fingers, but my personal view has been, and I'm only quoting what Mr. Fali Nariman had said once when he was in Bombay, many decades ago. We lack what is called the culture of arbitration. We develop a mindset, and the mindset that we need to develop is that arbitration is meant to be a efficient method of dispute resolution which must be adopted with the idea that it is the choice which the parties have made of having a judge or judges of their choice. And it is our duty as lawyers to achieve that goal for the litigant or for the dispute parties who are in dispute, to have that goal achieved in the fastest and the most efficient manner possible. Are we able to provide it? I will give you an example. I do not take up domestic arbitrations at all. Now again, you may say why. I'll be pretty blunt about it because I don't think we have the culture required to treat arbitrations as an alternative form of dispute resolution meant to sidestep the normal judicial machinery that exists and provide a speedier, efficient remedy to the litigant. Most of us take it as a pastime. We try to kind of fit it into our daily schedule by saying, why not have it at 5? Why not have it at 4? We'll do it from 5 to 8, maybe on Saturday. Today I'm not, I've got this matter. Tomorrow my witness is not there. Day after it is this, that. I mean, honestly, I think it's better not to pretend. Because if the same UCTRAL model has worked elsewhere, it can't be that there's something so wrong with that model that we are not able to work it. So we have to find fault within ourselves and not outside ourselves. That is the first thing. The second thing which I would like to talk about is the fact that, and again, please do not misunderstand, and I do not wish to point fingers towards any judge or any court. Whenever or wherever there is a possibility of making a judicial inroad, and there are plenty of them. Section 5 will say least interference from courts, but that's on paper. Take the practical aspect. Take any application, 9, 11, 14, 13, whatever, 17, challenge under to an arbitral award, interim award, 37, challenge to final award, 34 itself, 37 thereafter, Supreme Court thereafter. Take any of those, or 29A, extension of time, removal of arbitration, any judicial inroad that the Act permits today becomes one more application in a court of law which is heavily overburdened, which means you are in queue. Aap Qatar mein hai. Once you are in queue, you are in queue. So this is where I firmly believe that you cannot put the blame on the courts. What do you expect the judges to do? You look at your judge population ratio. What do you expect the judge to do? He has a docket of 100 cases a day. Do you seriously expect him to put everything aside in his role? 1996 Act, UCTRAL model, it is worked elsewhere. Let's all these litigations wait. Let these 100 people wait. Tomorrow I may have another 100, day after another 100. Let all of them wait. Let's dispose of this section 11 right now. Because it deals with the appointment of arbitrators. It's not possible. So what happens is we are not in a position. I mean, we all of us, I don't exclude myself. I'm part of that system. You take a 34, you take a 36. I'll give you another practical example. You have introduced section 36. What was the idea behind 36? 36 was meant to be a dampener. It was meant to be a deterrent. It was meant to make a dishonest challenger to an award pay a heavy price if it was a money award to challenge it, because it required him to deposit the entire amount like a money decree if he wanted a luxury of challenging or filing a section 34. That was the idea. Laudable, cannot complain, beautifully put, excellent. It would deter. That was the idea. Then you brought in an inroad, discretion. Once you bring in discretion, it means the judge has to apply his mind. If the judge has to apply his mind, he has to understand what the dispute is. If he has to understand the dispute, he has to then understand what the award is all about. Then he has to understand what is wrong with the award. Then he has to hear the other side. Then he has to pass a speaking order. If he passes a speaking order, he is capable of being challenged. If he is challenged, the appellate court has to go through the same thing. If that is done, the matter can go to Supreme Court. I'm not, again, please don't misunderstand. I'm only talking of the practicalities of the problems today. It's one judicial inroad I'm talking about, and there are several, as I identified earlier. So that is the reason why we are in a situation where we dream of a 5 trillion economy. We are talking about it. We are talking of ease of doing business. Business is an enterprise done for profit. Profit will be wiped out if we do not have an ADR system. And that is the reason why there should be a very strong and conscious move towards institutionalization. And institutionalization, which is what I have to commend what the Gujarat High Court has done and congratulate and compliment them, because institutions as an alternative to ad hoc arbitrations provide several solutions which are not in that sense available in the ad hoc system of arbitration. And the first thing is, and which is what the topic of the day we are supposed to, Shyam and I are about to talk to you about, is bringing about discipline in the advocates and in the arbitrators. Now, we'll talk about it in greater detail a little later, but an institution brings that about because the first thing is institutions care for accountability. And when there is accountability, even if you are whatever advocate you may be or whatever your standing may be or however busy you may be, the institution will say, either you come here at 10:30 or you're sorry, we'll have to go on without you. If the arbitrator does not come on time, the institution will say, this will be the last arbitration you will do. So this is why these institutions are bringing about a much greater degree of accountability, uniformity, professionalism, and make the advocate and the entire system accountable. The result is that the percentage of decisions, whether they be interim under the emergency arbitration or whether they be final awards, the percentage of challenges automatically comes down. And when that happens, the faith in the institution goes up. And that is the way, in my view, alone, we may be able to think of reaching the goal of a 5 trillion economy. So I think with this, one more thought, and I'll hand it over to Shyam. I think I've spoken a lot. Another thing that business and commerce operates on is what is the common concept of time value of money. As you know, under the IBC, you can claim a debt only if there is time value of money involved in it. But time value of money is actually the bedrock of commerce, because commerce cannot wait. The flow of money cannot wait. If you stop the flow of money, you interfere with the time value of money concept, and commerce will come to a standstill. So all of this, ultimately, if you want to bring about industrialization, if you want to bring about the services here, you want to bring about businesses here, you have the gift city here, whatever it may be today by, by methodology or SWIFT or whatever, money can be transferred from one country to another in a matter of seconds. But if commerce comes to a halt, it cannot be transferred. There will be no movement of money. And that is another reason why I feel that institutionalization would go a long way. Thank you so much. Thank you.
Okay, thank you. Good afternoon, and thank you very much for this very kind invitation. It's truly a pleasure to be here in Ahmedabad, and what a fantastic setting. I don't think there's any comparable auditorium in any court complex anywhere in the country. So it's really a joy to be here. And we were having interactions, Janak and I, with the Chief Justice. And she said that I must speak to, amongst others, the young lawyers in this room. And it's really a pleasure to be speaking to all the young lawyers who've attended this particular conference. I think it's going to be very enriching for you. And I would like to start then with something which Janak and I witnessed just a few weeks ago. And that's the first part of the topic. The topic is ethical, efficient, and effective dispute resolution process. Let me spend a little time on ethics. Just a few weeks ago, as I mentioned, the Bombay Bar Association had a tea party to felicitate the incoming Advocate General, Dr. Sathe, Dr. Milind Sathe. And there were a lot of members of the Bombay Bar over there. And after there was a speech by the president, and then Dr. Sathe started in response. And it struck me that he began his speech very early with a reference to J.M. Thakur, Shankarbai, as he was popularly known. And Dr. Sathe said that amongst the lawyers who influenced him, whom he held as a model, was the first Advocate General of Gujarat. And I think he mentioned that because you had a succession of Advocate Generals who, you know, upheld very, very high standards and continue to uphold very high standards. But I think the point which I took away was that while Shankarbai and J.M. Thakur was, you know, essentially here, a Gujarat practitioner practicing in Gujarat, but his reputation for rectitude, for ethics, for integrity, for how to present a case, I learned that he had modeled himself on his mama, his Mota Mama, who was MC Setalwat. And, you know, that's, all of us have sort of role models in the profession, and we, to a lesser or a larger extent, try and at least emulate them. And that's how the traditions of the bar continue. But this struck me as a very powerful example which Dr. Sathe gave. And it was because J.M. Thakur, you know, his reputation for ethical work, for being independent, and for saying it as it is to a court is something which continues to inspire new generations of lawyers, as I'm sure it will continue to inspire each one of you. I want to also mention on the point of ethics, and there is a Gujarat connection here as well. And I was thinking, if I had to recommend just one book to the young lawyers in this hall, which should that be? And I was scratching my head, and perhaps you should dip into Chagla's autobiography, which is called Roses in December. And it's got an appendix at the end, which has a connection to Ahmedabad. This is about an incident, or rather an event, which occurred on the 12th of October, 1975. This is during the emergency. And Chagla was here in Ahmedabad, and there was a public meeting where he made an extempore address. And the extempore address, sort of during the emergency, was of course to the citizenry of Ahmedabad, but it was also to the lawyers in that room. And it was about courage, and it was about the importance of ethics in a democracy. It was about don't lose hope. He has that line towards the end of his speech where he says that I'm an old man, and I see the night very dark. But when the night is the darkest, the dawn is not far. So for the young lawyers, there may be times when you feel that the things aren't working out very well. But I can tell you that our system here in India is generous enough, it's capacious enough for ethical people like Mr. Dwarkadas to reach at a very, very high level of the profession, the highest level of the profession. So I implore each one of you, whether it's in your arbitration practice or otherwise, to continue to hold these extraordinarily high standards, which the Gujarat bar can be justly proud of. I think I'm continuously amazed that the number of representations which frequently come from the bar collectively, discreetly, to the Supreme Court, from the Gujarat bar discreetly to the Supreme Court on issues of importance and concern is something which speaks of a vigilant bar, which speaks of a courageous bar, and which speaks of a bar which will discharge its duties with great efficiency. So it's really a proud moment for me to be here as well. The second bucket which I wanted to talk on was really what Janak spoke about as well, which is where are we when we have aspirations in terms of being, we're already around, by some measures, the fourth largest economy in the world. By 2030, we expect to be the third largest economy in the world. That's an enormous responsibility. But with that responsibility, if we are to reach that target, as Mr. Dwarkadas mentioned, we are going to have not just the highways for the traffic in terms of cars, but the highways for dispute resolution as well. And where are those? So it's important for us to hold a mirror up and find out where is this dispute resolution machinery today. Mr. Dwarkadas told us about the Commercial Courts Act, but there's something which is much more insidious in our system. And you may not realize it in Gujarat, because Gujarat continues to have, it's one of our few jurisdictions in our states, which continues to have a cap on ad valorem court fees. So there's a limit in Gujarat, there's a limit in Maharashtra, West Bengal, Goa, Assam and some of the northeastern states have it, and Jammu and Kashmir has it. In the rest of the country, if you want to file a commercial action for recovery of money, there is no cap or limit on court fee. You just pay ad valorem, the percentages keep going down, but it's a huge amount of money which you're paying. So effectively what's happened in India is that in many, many parts of the country, all that a civil lawyer can promise his client is really in the nature of an injunction. So it's essentially injunction suits, because recovery of money suits, you pay an ad valorem court fee without a cap or a limit, and it takes decades for decision. So it's really a complete zero in terms of offering an avenue for dispute resolution to the citizenry. So where do we go? And this is where new institutions, like the one which was inaugurated, the building which was inaugurated today, is really a promise for the future and has immense and terrific potential. That, of course, comes with certain pitfalls, but let's just list a few of the imperatives which we need. We need, first and foremost, an institutional machinery and not an ad hoc machinery. I think if you want to have dispute resolution where you can recover money and not just get an injunction, you need institutions. And the first of those institutions are going to be the ones which formalize the process for arbitration, because arbitration is the only way we have in India for businessmen to really recover money. The other systems are too tedious, too laborious, and they go on and on. Institutional arbitration, therefore, is perhaps something which we can bank on, try to tweak, try to adjust and adapt for the local environment and try and make it work. Which takes me to my next point in terms of what does the institution require? What do we need to do and what do we need to get right? The first thing which we need to do, and Justice Sikri alluded to that, we need to be aware of where we are in the rest of the world. He mentioned 2 or 3 things. One, he mentioned that the form of our awards, the way we write them, the way we analyze it, that has to be consistent broadly with what is happening in the rest of the world. He gave that very good example when he tried to correct the Senior Arbitrators Award, and just bring the language a little closer to what the international norm is. And he was, of course, told to sort of mind his own business as a junior arbitrator, so to speak. But that's just one part of it. There is another thing which I should point out, because internationally, if you're looking at it, I mean, the arbitration center here attached to the Gujarat High Court is primarily going to be, perhaps, at least in the initial years, for domestic arbitration. But it has an international element to it, an international flavor to it. So we have to be aware of what's happening in the rest of the world. And in the rest of the world, let me tell you, the moment you mention something like the Delhi High Court Arbitration Center or the Gujarat High Court Arbitration Center, people recoil. Because to the rest of the world, arbitration is something away from courts. It's something far away from courts. How can your judges be involved in arbitration is the first question you're asked. And the second is, that is why you have these type of judgments coming out of India, where there is such a lot of interference. So we have to, now you've got the center here. So you are going to have to, here in Gujarat, come up with a new imagination, a new structure, where yes, for the initial period in terms of establishment and setting the rails and putting the guardrails and putting the rules there, you needed the parenting by the Gujarat High Court. Maybe it will continue, but you will have to come up with some norms which ensure that as far as an international party doing business in Gujarat is satisfied that yes, this, while in the Gujarat High Court precinct, is something distinct. Its board of directors, the people who look after, who supervise it, who manage it, in the initial years were very closely attached to the Gujarat High Court. But now you can see that there's a highway and a roadway for independence so that it is not mixed up, so to speak, with the judges. I'll come to another point. Mr. Dwarkadas alluded to that as well. You are going to, at some point, have to have, if this is the only manner in which we solve commercial disputes in this country, a dedicated arbitration bar. I see it for the first time coming up in some segments and chambers in Mumbai. It's been there for some segments and some chambers in Delhi as well. But I'm not sure about the position here in Gujarat, so I speak from a position of innocence. But over a period of time, there will have to be specialization with an arbitration bar and dedicated arbitrators. So it's not, as Janak was mentioning, something which we put at 5 p.m. and on weekends, but something which you do full time during the day. That transition has to be made. If you want confidence in this particular new institutional framework which is set up, then it will have to be something 9 to 5. It can't be something which is relegated. That's a big structural change which will have to come in the as we move along to ensure public confidence. I have another suggestion to make. Because it's a new institution, because it's coming up, there is a notion and a concept of a citizen's charter. We can call it a user's charter. Maybe the Gujarat High Court Arbitration Center can come up and declare a citizen's charter or a user's charter. What will that user's charter provide? What will it proclaim? It will obviously assure the users that this new institutional framework will guarantee you the following. What might that be? An assurance in terms of completion of an arbitration within a particular time. That's what businessmen are looking for. Number 2, some estimation in terms of what the fee and costs are going to be. Number three, within what period of time will we assure you generally that you will have your first bite or first chance for interim relief if there is an urgent requirement, and thereafter a regular interim hearing, and the final hearing as I indicated. So if you are able to project to the world that, look, this is on our front door, anyone using this facility, we will assure this to them, then I think it becomes a great starting point to build confidence. Then it, of course, requires a lot of work because everyone on that panel has to cooperate. Your institutional machinery, which is supporting the entire process, has to cooperate and ensure that those dates and times are indeed met. But I think it is doable, particularly for a new institution, such as the one where you have this magnificent complex. The physical infrastructure is there now, and the people infrastructure is definitely there as well. The people infrastructure is there because you have, I saw the panels of judges who have judges, professional arbitrators, young advocates. I mean, without again, to borrow Janak's expression, without meaning any disrespect to retired justices, I have noticed that young lawyers in particular have a present reputation to defend and build on. And sometimes these young lawyers make excellent arbitrators because they know there can't be a squeak out there on their integrity, on their competence, on their efficiency. So that you see a young arbitrators award which is coming out, it is just so beautifully packaged and it's done so quickly and swiftly because you're living on a present, you're building a present reputation. You're not leaning on some past reputation. So just think about it. And I was very pleased to note that there were empaneled on the slide which we saw, or in that film which we saw in the morning, young lawyers and advocates, arbitrators, retired justices, all a very good set of people from whom persons can use from. Now, the Advocate General was here in the morning, so we're going to need him, and we're going to need the help of some influential judges over here for that next step which I'm suggesting. The next step I'm suggesting is that Gujarat, along with a few other states like Madhya Pradesh and Chhattisgarh, have this statute by which all works contracts go straight to the government tribunal. Now, I'll tell you very frankly, if this organization is to fly, and it should fly, please work on an amendment to that act. At least give a choice to the contractor to go either to the government-appointed tribunal, because, I mean, I suppose, abolishing a government-appointed tribunal is next to impossible. But maybe you can give them a choice through an amendment that either you come here or you go there. I think that will help give you the core initial set of cases to build this particular institution and then to guide it in the right direction. But I think you need this amendment here in Gujarat to really give a fillip and a boost insofar as the arbitration process and this new young institution, which is just laying out the essential steps which it has to take so that it builds into a very healthy future. The final set of points that I'll make is, I've just titled it that, do we want a banyan tree or do we want bonsai? Now, bonsai, as you know, is that, those trees are very beautiful, but then you keep snipping at the roots, and that magnificent tree, or whatever, the tree is a very small kind of plant at the end of it, though it's a full-grown tree. Or you have a magnificent banyan tree. What do we want in terms of this institution? If you are going to have judicial intervention in this country where you keep snipping at the roots, you are going to remain stunted and small. So essentially, and this is a cultural transition, this is a mental transition which we have to make across the judiciary. There will be, look, let me come at the same point from another angle. The public sector is going to remain here in India for a while. You're going to have large public sector investments. And as you have seen from the judgments which come up from the Supreme Court, from the High Courts, from the curative jurisdiction of the Supreme Court in arbitration cases, if you please. If there's a public sector undertaking on one side, you know, the clarity of thought, which is so evident in most of our Supreme Court judgment, suddenly becomes blurred and foggy. And then you come up with some sort of a result which you think is correct, but which has been reached through a very painstaking, wringing kind of process, which really shakes the foundations of your trust in arbitration as being a dispute resolution machinery with good results. Because it's institutional, I feel and I hope that it will be partly insulated, at least from the challenges of ad hoc arbitral tribunals to some extent. But if we want a magnificent banyan tree to grow, the courts are going to have to say, maybe something wrong happened, maybe it's a public sector company, but I'm still going to have a hands-off approach in the larger interests of the country and the system so that the institutional arbitration machinery is protected and is allowed to flourish. I thank you all for your time.
Thank you, sir, for a very practically insightful and engaging session. Let us now open the floor for discussion. We invite Mr. Jaimin Dave and Ms. Gargi Vyas, learned advocates, to join the guests on stage for an interactive session.
So since you spoke about the need for an arbitration bar, what changes do you think a lawyer should bring in its approach in terms of pleadings, evidence, and arguments in support of institutional arbitration?
No, I think, look, there's the individual advocate is obviously most concerned about his or her practice and how it's going to develop and evolve. So when we speak about things, or when I spoke about a dedicated arbitration bar, I think if we want this new institution to grow and expand, it has to become part of the mainstay system, just as you have other courts. So let me, this is not necessarily everyone's favorite organization, but I want to mention it. I think one of the biggest expansions of dispute resolution platforms in our country occurred with the passage of the Consumer Protection Act. That really, there were a whole set of disputes in our country which just couldn't get resolved. And then you now have, you take it for granted today that you have these consumer fora. There may be limitations, but disputes which just have to be forgotten could now be resolved in a reasonably efficient manner. So if arbitration, institutional arbitration is going to be that vehicle by which we open up a whole area of dispute resolution, you're going to have a professional set of arbitrators who work through the day, and you're going to have lawyers who work through the day. Then you can't say, oh, I've got a court matter, so I'm going to go there and I'm going to miss out on this arbitration. It's in that context that I meant that a professional full-time arbitration bar is a necessary adjunct for a successful institutional arbitration center like the one which we just have here.
So, sir, when we talk about efficiency in arbitration, recently Honorable Supreme Court has delivered a judgment in C. Veluswamy versus K. Indira that Section 29A extension can be granted even post-arbitral award. What are your views on that, and would it be detrimental to the desired efficiency both in ad hoc and institutional arbitration?
Personally, I would not like to comment upon any judgment of the Supreme Court. I don't think this is the proper forum for it, but let me address the question nevertheless. I personally believe that because of the system we follow of non-super specialization. Again, I'm sorry I keep repeating, I don't mean any disrespect to anybody, but you can't have 24 Supreme Courts or 15 Supreme Courts. I mean, I'm being very honest about it. I know the problem is we have, unfortunately, too many, the backlog is just too heavy, and you can't sit like the US Supreme Court en banc, that is all the judges at the same time. What is happening is that if you have 12 Supreme Courts or 15 Supreme Courts, because they are broken up into benches of 2 and 3 and 5 and whatever, and a bench with a particular bent of mind, I'll only put it that way, decides that this section ought to be interpreted this way, and then gives its interpretation on it. Who knows whether 5 years down the road it will be upheld? I don't know. I mean, Shyam will tell you better than me. As he mentioned, even in curative petitions, we have seen what is happening. The point I'm trying to make is this itself is ad hocism. I'm sorry, I may be sounding a little harsh, but I feel strongly that if you have a bench dedicated to arbitrations, even in the Supreme Court, even in our high courts, there will be a great degree of uniformity, and it will help shape not only the act, which should not be touched and retouched and reopened and re-argued and reassessed again and again. It would help to create the confidence that a litigant deserves more than desires. He deserves to know that this is the final word on the subject and it will not be disturbed. I think that that message has to go loud and clear. And that will happen only if you have, in that sense, you have a vertical system where, arbitrations will remain. Like you have so many courts where there is taxation, tax lawyers, tax judges, who will, before even a matter is called out, will say, sorry, this is covered. Sorry, this we are not going to reopen. Sorry, we have already decided. That's how it should be. It should not be this laissez-faire, okay, let's look at 29A. Okay, in this case, but now, we feel there is this word may, here it is shall, so we will do it. I mean, frankly, I'm not commenting on the reasoning of the judges. I'm only saying this discourages, and this is exactly why we are where we are today with the 1996 Act. That I would like to leave it at that. I think it's not a question of whether is this section or that section. I don't think we have the degree of certainty required coming from the highest court. That's all I would like to leave it at that.
So, sir, when we discuss about degree of certainty, and when we discussed ad hoc arbitrations, issues related to ethics, fraud, and delay keeps popping up. Now, in that context, do you believe that institutional arbitrations will be immune from those concerns? Because at the end of the day, people governing those institutional arbitration will be the same.
I think I would like to give two examples, or rather talk about two cases that I was involved in where where the arbitration was conducted through an institution. And probably it might answer the question you put to me. One was where, and this probably also answers to an extent to the question Shyam was just put about how do you bring about greater ethical standards amongst the advocates. Let me give you one example which happened in Ahmedabad many, many years ago when I was a junior to a senior counsel. The arbitration was between Aravind Mills of Ahmedabad and a Sri Lankan mill, with whom Aravind had entered into a management contract. where they had indicated that your mill efficiency of your textile mill can be improved if you take up the following measures, etc., without giving any guarantee that the result will be or the profits will be whatever. They just projected profits on the basis of improved production. The Colomban, mill from Colombo brought the Chief Justice, the retired Chief Justice of Sri Lanka, to argue the case. And the arbitrator was one Mr. Neil Kaplan, who was a QC at that time. And he was appointed by one of the institutions, I don't remember, it was LCIA or one of those. And he came down sole arbitrator. And to be a sole arbitrator in an institution requires you to have passed through a stringent kind of, I wouldn't say a test, but quality standard that you are required to display before you can be appointed a sole arbitrator, because you're first put on a panel, you're seen, you're judged by your performance, your discipline, your dedication, your ability to absorb the facts of the case, your behavior, general demeanor in the arbitration, how you get along with your co-arbitrators. There are so many parameters which you may not even be aware of, but the arbitrators are being judged on those parameters. And finally, if you go through those hoops, you've then qualified to be a sole arbitrator. And even thereafter, it's not the end of the story. Your awards, the quickness with which you deliver the award, the quality of your award, whether it is upheld, set aside, all those factors are taken into account. So you're under constant scrutiny. You're accountable, as I said earlier. The institution wants to ensure that the institution is looked upon by the litigating parties as somebody who will deliver a quality award. It is an award. The institution takes it as an award rendered by the institution, not by the individual. The individual, in that sense, or the individuals merge and become part of the institution. So when you talk of an LCIA award, you don't talk about an award of X arbitrator or Y arbitrator or panel of arbitrators. You refer to it as an SIAC, ICC, or Hong Kong International Arbitration Center, or whatever. So that is how they want to be, the institution wants to be identified. It is very important to understand, because you are setting up an institution here. It is not about individuals. I think Shyam and I are both trying to make the same point, that if you are at the fledgling stage where you are about to launch something, the first thing you need to focus on is you are setting up an institution which is going to hold itself out for the promises, as Shyam rightly put it, or charter that you put forward, that we believe that this is what we will be able to deliver. So the individual, in that sense, becomes subservient to the institution. So the example I was trying to give you about Neil Kaplan, it was my first exposure to an international arbitration. And what I wanted to talk about was that on the last day of the arbitration, he came up to me during the lunch break and he asked me, "So what is going to be your next assignment?" I cannot tell you how stupid I felt. Because I felt stupid because there was no next assignment. I was going to go back to the Bombay High Court library, which we used to call the taxi stand, and wait there to be picked up by the next customer. So I kind of very sheepishly looked down and I said, "I'm sorry, I didn't understand your question." And he took out his diary and he showed it to me. And it shocked the hell out of me. For the next 2.5 years, 2.5 years, he did not have a date to give. He was completely and totally taken up with one arbitration after the other of that institution, for which he had to dedicate X number of days to read up, Y number of days for arguments and hearing, X number of days to prepare the award and deliver it on so and so date. He had it mapped out right for 2.5 years. That was the dedication with which he was recognized as being worthy enough of being the sole arbitrator for that particular institution. It should be a lesson for us to understand this is not a pastime job. Please don't look at it that way, whether you are the advocate or you are. So when I told him that we don't function that way, I don't think he quite appreciated it or enjoyed hearing the answer, but that's another story. The other example I wanted to give you was about an arbitration I did in London, where there were 3 arbitrators, again illustrating how important the role of the arbitrator is to make the institution look good. Okay? There was the chairman of the tribunal was David Wilson QC from New Zealand. There was Toby Landau from England, who is regarded as an authority on arbitrations today. And there was our Mr. P. Chidambaram as the third arbitrator. I cannot tell you how difficult they made it for counsel appearing, myself on one side and some American lawyer on the other side. The record was 40 files, 40 files, box files. They systemized their filing by giving it a file number and a document number. So it will be file 20, document so-and-so, page so-and-so. The arbitration was scheduled for 1 whole week, which meant I had to work a minimum of 20 hours every day, every single day of the 7 days. There was no time to sleep. There was no time to do anything. It was like arbitration, work, arbitration, prepare, because everything was given a timeline. 45 minutes for cross-examination, 30 minutes for evidence, 40 minutes for this, 40 minutes. Everything was timed from before. Pleadings, opening statement, closing statement, everything was chalked out. And what I wanted to tell you about the arbitrators was they were competing amongst themselves, the 3 of them. They would say, Mr. Dwarkadas, document number so, file number so, page so, line so, what do you have to say? And there were no computers in those days, let me tell you, and yet this was the level. And the other arbitrator would say, in their very polite British way, maybe, Mr. Dwarkadas, the answer is in line 25, if I am not mistaken. And you look at the other arbitrator also. Frankly, I'll tell you, it was embarrassing. I didn't know the line which the first arbitrator mentioned, nor the one the other one mentioned. But I had to look very intelligent and say absolutely correct. So I'm only illustrating this to show the level of professionalism that these institutions bring about. And it is only for that reason that I'll give you a few statistics. I'm sorry, I'm maybe taking up a little more time, but why are we in the business of exporting arbitrations? Why are we burning up foreign exchange? Singapore International Arbitration Center reported or recorded 663 new cases in 2023. 93% were international. They made a business out of it. They are earning huge foreign exchange out of it. Indian parties were involved in 160. 24%. 24%. The International Court of Arbitration, ICC, headquartered in Paris, received 929 new filings in 2020 from 145 countries, including 79 involving Indian parties. The London Court of International Arbitration, LCIA, received 293 referrals in 2022 from parties across 91 countries. 88% were from outside the UK. Located in UK, 88% outside the UK. 24% from Asia alone. Hong Kong International Arbitration Center, 500 filings in 2023, 89% international. International Center for Dispute Resolution, which is part of the American Arbitration Association and which operates globally, has now set up a branch in Singapore as its only branch outside the United States for servicing Asia. What should these figures and statistics tell us? What should it tell us? We arbitrate a dispute, professionalism that is required. We seem to go outside our country. Why should we? Why should it not be the Gujarat Arbitration Center? Let us strive to make this the hub where the Prime Minister, as we were told, wants it to be, where the Chief Minister of Gujarat said he would like it to be, where the Chief Justice of our court said that she would like this to be. If we want that to happen, the level of professionalism that we require to put in is what I gave by way of 2 illustrations. I hope I've answered your question.
So picking up further from thank you. So picking up further from this discussion, what other checks and balances would you recommend in the existing mechanism so that the institutional arbitration can be more fine-tuned?
So I think it came up in the course of the deliberations earlier. So there are 2 elements to make it, to build public confidence. One, of course, there's the obvious elements which you see in a court, which will be there in the arbitration as well. And what is that element? The final question and the final test for the integrity of any court is the quality of its judgments. Now, the court process is a public process, and courts therefore are constantly under scrutiny. And Janak and when I joined the Bombay High Court, the preeminent judge at that time was in the mid-90s was Justice Paintsay. And if anything went wrong in the lower court, people would say, we'll take it to Justice Paintsay's court, because he was the appellate court. So that was the public confidence which people had. And that was because of the quality of the decision. You knew the decision. It was not some beautifully written prose or anything like that, but the eventual outcome was something which was fair and just. So you have this happening for courts through the process of declaring judgments. The arbitration process is by and large confidential and private, but reputation will go around. So if you want really you want to build a reputation like the Singapore Arbitration Center or London Court of International Arbitration, the eventual quality of the decision must be something which, when it gets known generally in the business and trade, it would be something which is respected and which builds the reputation. So that's one very important thing which has to happen. The second part is that in many of these international organizations, and here again, we have to learn. there's not just the case management, which is one part of it, but there is a scrutiny of the award. So the draft award, it's not as if the institution is putting its decision to replace the arbitrator's award. But because, as Justice Sikri had mentioned, they are styled and written out in a particular fashion, the internal scrutiny will be, have all these points been addressed? Would you like to really look at this paragraph versus that paragraph? Because on a review, we find there is an inconsistency in the awards. So institutions, this is not intermeddling in an award. But before the award goes out into the world, or at least to the parties who are involved, there is globally an evolving filtration process where you filter out at least some of the dross which you feel should not make it to the next stage. So there was a certain awkwardness which all of us remember from the news reports, where in an international arbitration, I believe Singapore based, where you suddenly found some wrong paragraphs from a particular award featuring in another, a copy paste kind of a situation. But one part of it was the reasoning. The other part of it were facts which were a little alien to the award, seemed to have crept in. Now, that is the sort of thing which can be picked out. I mean, nobody is absolving the arbitral tribunal. But I'm saying that if you want to build your reputation, your center cannot allow an award to go out which has inconsistencies, which doesn't deal with 2 or 3 of the primary issues which are noted. And that really enhances the prestige. So these are some of the low-hanging fruit which we can, consider building on if we have to really build a great institution. Thank you.
Thank you. So one more question. Now, as far as experts are concerned, how important is it to have a pre-existing panel as a part of an upcoming institutional arbitration center?
So, look, this again came up in the course of the morning session. Justice Sikri had specifically mentioned the Indian Merchants Chamber, IMC arbitrations. So similarly, Mumbai, it's actually, I'm sure it's in Ahmedabad as well. There was a huge textile industry out of Mumbai at one point of time. And there were these, there were cotton, there were not institutes, but there were associations of cotton traders, etc., etc. But these kind of disputes on quality, etc., would arise. Just now, you have also the Bombay Stock Exchange dispute resolution internal mechanism. You will very seldom find that a stock exchange award creeps all the way up to the Supreme Court of India, because the people there know what each one of the traders is talking about. Similarly, in Indian Merchant Chambers, apart from the practicality and the experience, they know, they understand what's happening. It's not a theoretical take on X or Y or Z. So I think it would be very useful. There are certain areas where clearly a state like Gujarat, even locally, would require. So globally, construction law is one field where you have specialist arbitrators. Energy law is another field where you have, real specialist arbitrators. So they understand that. I think it's very similar. When Janak mentioned the specialist, I was actually thinking of the Gujarat High Court and the 1960s. In the 1960s, the ITR reports, the income tax reports, there used to be a bench of the Gujarat High Court in the 60s and the 70s, and a bench of the Bombay High Court, which was producing probably 80% of the case law on essential principles which we follow till today, because there was a specialist bench. So that's how, you build a reputation, you set out the essential benchmarks, and then people have confidence. At the end of the day, what are we doing? We're rendering a service to society and to that consumer, where he wants a quick and fair, resolution. And I suppose with AI, it's going to make things, I hope, easier.
So, sir, taking Garge's question forward, when we talk about empaneling specialized arbitrators, who are well versed with their field, let's say pharma, construction, etc. Do you think that they are not well equipped with law and that may be drawback for the purpose of impaneling them in the institutional arbitrations?
No, it all depends. I mean, recently I was asked to speak at one of the L&T, they were hosting a seminar on dispute resolution more for the benefit of industry, that is people in the infrastructure in their field. And similar point was raised over there that to what extent should we have lawyers or judges as arbitrators, and whether it would not be advisable instead to leave it to the experts. So the answer that I gave was more or less in these terms, namely that it depends on the nature of the dispute. A dispute could involve partly an interpretation of a particular clause, which an expert in the field of infrastructure may not be qualified to do. And say 10%, I'm just giving a rough and ready here, say 10% of it has to do with interpretation. And the balance 90% has to do, let us say, just as an example, the dispute arises on account of the fact that there were time delays, cost accretion. How is it to be compensated? And part of it, whether it should be, whether such a claim can or ought to be made, is itself dependent upon the interpretation of a particular clause which deals with the subject of time delays, okay, or cost escalation. So the panel could comprise of two experts or three experts, two experts in the field of infrastructure, and one with a judicial background. It could be a lawyer, it could be a judge, who would first decide whether or not there is a case to be considered on the right to claim for escalation, and then guide the experts on that particular interpretation and say, well, this is my view on the interpretation. Now you work out what the compensation, if any, ought to be based on your expert analysis of the subject. I mean, this is just an example I'm giving. Similarly, as Shyam mentioned, it could be a stock exchange related dispute or any of these, cotton exchange, like cotton traders disputes. Now, there are sometimes elements of interpretation of law involved. So I would say that the legal part of the challenge or the jurisdictional part of the challenge could be left to one of the panelists, and maybe the commercial part of it could be left to the experts, and yet the award would still be a very balanced award because it would comprise of both the legal part as well as the technical part. Thank you.
Thank you so much for the discussion, but if time permits, we can take one or two questions from the audience also, so that they are also curious to sort of. Anyone in the audience who just stay.
Hello. My question to Mr. Senior Advocate Shyam Diwan. Does arbitration, despite of ensuring the speedy resolution, remain inaccessible to many due to its high cost? As you told that alternative to tribunal arbitration must be cost effective to achieve a meaningful success. So, what are the to make it bit little bit cost friendly?
Yeah, I think that's an excellent question. And I think for institutional arbitration, it's something which can really be wired in to your rules and regulations. So first, in the context of ad hoc arbitrations, my experience is there are a lot of persons complain in India that we first have to pay the arbitrators, and then there's a full-fledged process through the court system again a second time. So you're really paying twice. So you're paying your lawyers and the arbitrators at one stage and then through the court process. So it's just an additional layer. So I think that's a legitimate criticism which a number of clients have. I think with the institution being set up, I think you can certainly have rules and bans, and there will be a scale of fees which the institution can pronounce and project. There's just one point which, again, speaking to your costs issue, I think since the Gujarat High Court has set up this arbitration center, a very, very important channel of work is the chambers of commerce. So what you find is that there are chambers of commerce and industry which have a need for dispute resolution machineries which are cost effective. They're looking for that. And they are looking for centers and institutions which can assure them that we will have at a reasonable cost, say, whatever the scale is, a resolution within a year and a half in the context of a domestic arbitration. So I think the question lends itself to an opportunity to have a menu card of rates, and that menu card of rates can be made available to the public. I'm sure it will be a reasonable rate, etc. Chances are that it will be considerably efficient if it's run in a tight institutional manner instead of an ad hoc manner. So I think that's my general answer, which is that one way of controlling costs in the institutional context is to enhance efficiency. And then if there's a reputation for that institutional award, chances of a challenge, etc., and the whole thing getting mired over there is likely to be a little less.
Thank you, sir. One more. Sorry.
Sir,
This would be, so we just like this last question, after which we close. So.
Verification. So first of all, you have delivered a classic lectures on the ethics and of the institutional arbitrations. In fact, you have also compared with the Patel MP Contract Dispute Arbitration Tribunal. And presently, I am working as a chairman of the Gujarat Public Purse Arbitration Tribunal. In the year 2024, that is on 16 December 2024, there is one notification from the government of Gujarat through the legal department, wherein every works contract pertains to the municipal corporation, Nagarpalika, Panchayat, in all the three institutions, work contract would be covered and all the cases would be transferred to the Works Tribunal, Arbitration Tribunal. What I mean to say, that this is the first time in compared to the other state. I don't know about that, at least in Maharashtra, but at least in compared to the MP, the Gujarat, the state of the Gujarat is the first state where these three institutions have been referred to. Of course, not to the institutional arbitration, but to the statutory arbitration. So, of course, approximately 3,000 to 4,000 cases would be instituted in future. So the scope is enlarged. So what I mean to say that we will also recommend what you suggested, that how the more number of cases would refer to the institutional arbitrations. Thank you.
Thank you, sir. After this engaging discussion and our heartfelt gratitude to the speakers, let us take a moment to thank them. So we request Honorable Mr. Justice Anirudh P. Mai, Judge, High Court of Gujarat, and member of the Gujarat High Court Arbitration Center, to felicitate Mr. Janak Dwarkadas, the Senior Advocate. May we request Honorable Mr. Justice Pranav Trivedi, Judge, High Court of Gujarat and member of the Gujarat High Court Arbitration Center, to felicitate Mr. Shyam Diwan, Learned Senior Advocate. We now conclude the second session and the day. At the end of the day, today's seminar has truly strengthened our collective resolve to advance arbitration and alternative dispute resolution mechanisms. I sincerely thank all the distinguished speakers and participants for their valuable insights, thoughtful contributions, and active engagement throughout the sessions. Your presence and participation have made this seminar meaningful and impactful, and we look forward to continuing the important dialogue tomorrow together. We request all of you for high tea and good evening, and see you all tomorrow.
Hello. Yeah, before everybody leaves, members to come back by 10:15 and occupy your seats. All are requested to be on time so that we can start on time.